Okay, good morning, everyone. I want to start with a bit of housekeeping and ask everyone to make sure, please, to turn off their cell phones or turn them to silent. Make sure they're off the table. Also, anyone with Blackberries, the same, please, but make sure they're off the table for sure because there's feedback noise that is generated. For those of you that are in the audience, you should understand that agendas and material. So it's electronic, and I want to welcome any public comment that we have from the public. There are public comment sheets in the back. You need to fill them out. I'll try and remember to call on you. If I don't for some reason, please feel free to raise your hand. And I'm going to suggest you keep your comments to 3 minutes unless I would like to hear if there are any board members that want to hear from people for longer than 3 minutes. All right, so we'll have 3 minutes. And Ms. Thompson, could you raise your hand so people know who you are for people to give their slips to, please? Thank you. We've got significant vacancies on this board. We are at a bare minimum so that we will be taking breaks because otherwise we'll be breaking quorum. So understand that, you know, we'll take a 5-minute break. If anyone needs to leave, please let me know and we'll just break for a few minutes. There's also, we're planning to break around noon. There's a, for lunch, and the hotel is offering soup and salad for lunch, including iced tea for $10. The lunch is located in the cafe near the lobby and is open to the public as well. That's why I'm making the announcement. And then I'd like to begin as close to 1 o'clock our strategic planning meeting. So I'd like to start with roll call, please. Ms. Thompson, would you come forward and call the roll?
Dr. Carrion.
Here.
Ms. Chang. Dr. Diego.
Here.
Dr. DeRusso.
Here.
Dr. Levine.
Here.
Dr. Lowe.
Here.
Dr. Solomonson.
Here.
Ms. Shipsky.
Here.
Ms. Yaroslavsky.
Here.
We have a quorum.
Thank you very much. Moving on to number 2, public comments for items not on the agenda. I have 2 slips, so let me call on them. This is on number 2. Oh, sorry. Sorry. I thought it was, it's okay. So I have 3 slips. So we'll start with Mara Felsen, please come forward.
Good morning, ladies and gentlemen.
Sit down, relax.
Okay. Good morning, ladies and gentlemen of the board. My name is Mara Felsen. I am one of several volunteer attorneys who are addressing a matter that's going on in Calaveras County. I'm addressing you this morning for 2 reasons. One is there has been one patient complaint that has been filed against a particular doctor in Calaveras County. I don't intend to discuss the particulars of it, but I raise this to you because this is a matter that involves the wholesale denial of medical care to patients in Calaveras County because it happens to be a one-horse town with one hospital in it. And so we are trying to work with these patients, trying to assist them. And part of the reason I'm here this morning is because we want to make sure that we do everything in the right place. And because this involves not only one doctor, but many doctors, and it involves an entire hospital, which I know is not under your purview. But we've become aware that this one particular doctor that the complaint has been filed against has left the state. But I address you this morning to let you know that there will be multiple complaints that will be filed and that are coming down the pike. But our primary concern is for the patients in Calaveras County who are currently the medical director of the one hospital there has left, and all the patients there are currently in the lurch. And I don't know that this is anything. I don't know that this matter isn't, I know that it's not entirely in your purview because it deals with the entire hospital, but it deals with multiple doctors. And we wanted to ensure that that was brought to the attention of the board because it is a complex matter and it involves so many patients and more than one doctor. And the complaint was filed before the one particular doctor left the state. So that's really the essence of what I came to describe to you, and I just wanted to make you aware of that, and hopefully, as these things come in, you could pay particular attention. We're sort of at a loss, and we don't want this situation. We just would like the situation to change and the policy to change, and we've kept everything very under wraps because, frankly, we don't want it to be a media circus. There's enough problems that we have right now that this is something that it seems that once it gets into the right hands, it will be addressed because it is so egregious. But since these doctors are licensees of the board, and because procedurally this is a confusing matter because it necessarily involves so many patients that have been affected, I just wanted to raise that to you. And if you have any guidance, I know that that's not usually what you do in public comment. I know that you usually do something in terms of either putting it as an agenda item for the next meeting or not. I would hope, I don't know if it's appropriate to ask, but I would ask that you do that. I know that there's several months before the next quarterly meeting, but hopefully you could be on the lookout for this, and somehow we can help the patients of Calaveras County who are currently who are more or less bereft.
Okay, thank you very much for your comments. I apologize for not starting the conversation with the reminders to just sit for a minute. The public to understand that this is an opportunity for the public to have, during public comment, an opportunity to speak to this board. This is not a conversation. So you will not get a response other than our Chief of Enforcement is sitting in the audience. You're more than welcome to talk to her, and thank you for your comments. It's also not going to be agendized, just to let you know up front.
And who is it, the Chief Enforcement?
Renee Threadgill. Renee Threadgill, her hands in the air.
Okay, thank you so much.
Thank you. Anything else? Okay. So that's, thank you very much. The next person has a comment is Frank Cuny. We're glad to see you here, Frank.
Glad to be here. And my car did break down coming to this one, too.
Oh.
My name is Frank Cooney, and I'm the Executive Director of California Citizens for Health Freedom. And I brought some information and some gifts. Let me get these out of the way. As you may know, we hope to introduce a bill this next year, which I think will make the medical board easier to do, that integrative treatment of cancer will become legal in California. And the state law is very confusing on that. Physicians who do integrative treatment of cancer, safe and effective, can be arrested. Can be a criminal offense to do other than chemotherapy, radiation, and surgery. You'll find some Kiwis from Northern California back there. Here's a conference guideline from the 39th Annual Cancer Convention, which is held each year in here in Los Angeles area, actually Studio City. And I think you might find the speakers who speak at this type of conference on alternative treatment of cancer from Germany and from all over the world, speaking a little bit of information on nutrition. And there's a packet of information from a company in Japan that some of the licensed naturopathic doctors use with their patients to help as a complement in their cancer program and an integrative health program. And they're back there for your information if you'd like to look at them. Dr. Toth and I had the opportunity yesterday of visiting with a physician and patients in California, and this physician, according to the National Board of Alternative Medicine has the best record for treatment of cancer in the nation. You're doing alternative treatment, very holistic approach, a combination of things. And oddly enough, one of the patients that was there, has been there for some time, was from London, England, and traveled from London, England, because there's no place in the world like the treatment that she was receiving here in California. And if our bill passes, then we'll have lots of people coming to California for treatment and some of the best physicians in the nation. And we hope when we come time to introduce that bill, that the medical board will support that bill. I would have liked to ask the medical board to sponsor the bill, but your budget limits the type of meetings you have. But very seriously, I think it will help the medical board, help the physicians, but particularly help the patients. Thank you for your time.
Thank you very much. Dr. Formansky, you're on next.
Oh, these are in the back table.
Thank you very much.
I have a handout, which is a news article that I gave to your representative in the back. There's one for each of the board members if you want to read it. I don't know if you've received it or not.
Is that this?
Yeah, right. The topic that I'm going to talk about is the standardized testing that the medical board does. One of the tests that you do is the microcog test. It's a standardized test, but you do it in a peculiar way, and you send all of your new business and new cases, which are referrals of doctors, to one office in San Diego to the exclusion of all other vendors in the state. And the total amount of money that you've sent to this one little office is about $7 million for the microcog test. There are now 3 whistleblowers who say that there are problems with the microcog test in the way that it is administered, and that there might be a reason for the board to do an audit to see whether or not the microcog test is involved in some sort of test irregularities or possible test fraud. On the topic of test fraud, I've given you an article which is fairly current. It's about a scandal in Atlanta where a board similar to yours was trying to do the same kind of testing, doing competency testing on the students. And somebody came before the board and said, we think that that there's cheating going on in your tests. And it turns out that there was, but it wasn't the students that were cheating, it was the test administrators. And there were, according to this article, 82 of them confessed to cheating on the administration of the exam. So one of the reasons why, the reason that I'm here is to ask you to put this on your next agenda. I asked for it to be put on today's agenda, but your schedule did not accommodate, I wasn't accommodated on your schedule, so I'd like it to be put on the next time, which would be to authorize, number one, an audit of the last 500 doctors that you sent for standardized testing, specifically microcog, which is the problem. Microcog is a copyrighted test, so the board should have 500, if there have been 500 referrals, 500 invoices, 500 canceled checks, and 500 test reports. The test reports are each 30 pages long. If you've done 500 doctors, there should be 15,000 pages of valid test material, and Ms. Threadgill or Ms. Katie should have that in Sacramento or have reports of it. If nobody's looking to see if they are authentic tests, you may be in the same problem that the Atlanta board is. And I would say 15,000 pages, if we put it on this table, would be 6 or 7 feet high. If you've seen 15,000 pages of material, let me know. I made a request under the Records Act to see this material. That would be the invoices, the canceled checks, and the test material through San Diego, who are the people who pay for this, and they are running in circles trying to find it, and thus far haven't been able to find the necessary material to show that they ever did the test in a valid fashion. So this is evidence that the whistleblowers, there's now 3, 2 in San Diego and 1 in Sacramento, which say the microcog tests, if you've given it to 500 doctors, you don't have valid test results for 500 microcog tests. Also, no one knows if the staff in Sacramento, that is your highly placed people in the enforcement division, have actually been checking to see that the tests have been graded properly. And that was the problem in Atlanta. The people who were watching for the grading were actually grading falsified examinations. So I ask you to, number one, authorize an agenda item for next time, which is, I guess, your February meeting, and secondarily, consider the possibility of redesigning your standardized testing in general. Right now, you charge doctors $14,000 for what is really several $100s worth of testing. You have enough money in your contingency fund. You have $11 extra million above the limit, above your 4-month limit for the contingency fund. You could fund this for 10 years and not charge the doctors $14,000. You could have, in other words, you could fund it out of your surplus, which is an illegal surplus now in the contingency fund. If you want to check that, check page 114 of your current handout in the back, and that shows you have a surplus. You have 6.5 months worth of money in your contingency fund, which is too much money. That extra money could be used to redesign the way you give the standardized tests and take the burden off the doctors. And it is a burden. That's my request, that this be put on for the February meeting. Thank you.
Thank you very much. I don't have any other public comment slips, so we're going to move on to item number 3 and the approval of the minutes. Are there any... First, I need a motion to approve the actions, changes, or modifications. Do I have any public comment on the minutes? Seeing none, all those in favor, please say aye.
Aye.
Any opposed? Okay, we're going to move on to, thank you very much, to Ms. Shipsky and an access care update report, please.
We had a committee meeting yesterday, and we're fortunate to have a guest speaker, Dr. Tony Sullivan, who is the Dean Emeritus of a School of Nursing from Columbia School of Nursing in Missouri. Dr. Sullivan is the author of a book on collaborative care, and as we talk about affordable health care being implemented not only in California but throughout the United States, the issue of collaborative care becomes more important as we find ways to increase access to care for patients. I thought her presentation was very interesting in the sense that while it was theoretical, it laid out the parameters that need to be followed for successful collaborative practices. And as I mentioned at the committee, there's a couple of different definitions going around collaborative practice. As she focused on is the collaboration between physicians and nurses. There is an organization that's actually doing an entire conference and workshop on collaborative care, and it's regarding physicians and different specialties of physicians. And then there's collaborative care with the discussion of physicians and the cooperation between clinics and hospitals and such. So I think the definitions are out there, but I do think that what the focus that we had yesterday is one of the first things that we need to continue to discuss, and that is how, by recognizing the scope of practice for both physicians and advanced practice nurses, that we not only maintain those scopes of practices, but that we carefully, as we go forward to try to increase access to care, make certain that those lines are clearly delineated, at the same time encouraging collaboration between the two professions. So I look forward to having more committees, and I know today, and more meetings, and I know today in the strategic plan we're going to be talking a little bit about how we can, in fact, narrow the focus of access to care so that we can be most productive for the licensees. Thank you.
Thank you very much. Any questions? Any public comment? Okay, let's move on to Dr. Lowe and the Physician Update Committee, please.
As I understand it,
So she could address it.
Chairperson, you wanted a little introduction about PAs, is that correct?
Yes, please, sorry.
You wanted an introduction about what PAs do?
I would like that, please. I would like that
Fine.
everyone, I'd like to understand what PAs do, thank you, and
Okay.
what we do with these events.
So a physician assistant, or PA, is a licensed and highly skilled healthcare professional trained to provide patient evaluation, education, and healthcare services. The PA works with a physician to provide medical care and guidance needed by a patient. Each PA must be supervised by a physician. The physician supervises the PA either on-site or by telephone. The physician must always be available to the PA, and the physician is responsible for following the patient's progress. So a PA must attend a specialized medical training program associated with a medical school that includes classroom study and clinical experience. An academic degree or certificate is awarded upon graduation. Many PAs have 2- or 4-year academic degrees before entering the PA program, and most PA training programs require prior healthcare experience. So to practice in California, each PA must pass a rigorous national exam before being licensed by the PA committee. So the PA committee is actually part of the medical board, and the PA committee is responsible for consumer protection, making recommendations about the scope of practice of PAs, and providing information about PAs to the healthcare community and others. Now, the important document between the physician and the PA is called the Delegation of Services Agreement. That's very key, and it's essential that one be in place before the PA is allowed to practice. So with that background, I'd like to present the committee update. Any questions about that so far? So the PA committee held its most recent meeting on August 22nd, and here are some of the highlights. The PA committee has been successful in getting 2 regulation files approved. One requires that PAs post a, quote, notice to consumer, end quote, similar to the medical board requirement for physicians, and the other provides for enhancements in the PA enforcement program. Next, the PA committee will soon begin working on amending the disciplinary guidelines in order to incorporate SB 1441 standards. The diversion program contract is also being amended to include the standards. The PA committee also will soon begin working on regulations similar to those proposed by the medical board to allow out-of-state licensees to offer their professional services at sponsored free healthcare events. A subcommittee has been working on a draft of the 2012 Sunset Report, and the full PA committee reviewed the report during a teleconference on October 10th. The PA committee also discussed the interpretation of a supervising physician's personal presence. A subcommittee was appointed to review the regulation. The first meeting was held October 3rd, and will meet again on November 10th. Obviously, this subject is of keen interest to the medical board and its licensees, so the board staff and I will be working closely with the PA committee staff to ensure mutual concerns are positively addressed. Finally, there is a critical situation in that we have a staff vacancy within the PA committee, which is a very small organization, and that person was assigned to licensing. So this vacancy has increased the backlog in terms of licensing, and we still have not received authorization to fill that position. So within the last 2 months, the executive officer coordinated a temporary but significant reassignment of staff, clearing the backlog. But this has consequences to other programs. So we're desperately hoping to get a waiver to fill that position. That concludes my report. Any questions?
Thank you. Any questions? Thank you very much. So let's move on to the Enforcement Committee report. Dr. Lowe, please, item number 6.
Okay, enforcement. On September 14th, I met with the staff to discuss a plan to assist the enforcement program with improvements of the timelines. As a result of the meeting, I am appointing an enforcement subcommittee, which includes a board member to work with the staff to examine the details of the statistics and process in order to develop a plan of improvement that may include legislative recommendations. The Enforcement Committee can also help with the development of the evaluation report on the vertical enforcement program, which is due to the legislature in March 2012. Staff will also be looking at additional medical training opportunities for the administrative law judges, Deputy Attorney General, and the medical board enforcement staff, and report back to the Enforcement Committee. I volunteered to be the initial medical training liaison, and as such, I will be working with the staff in the Office of Administrative Hearing to provide the training regarding medical subjects that will begin in the spring or summer of 2012. That concludes my report.
Thank you very much. Are there any questions? So, Dr. Lowe, you're not off the hook yet. Let's go on to Special Faculty Permit Review Committee update, please. Number 7.
Okay. Specialty faculty permit.
The 2168?
Yes. So just as a little bit of background, under the article of 8.5 of the Medical Practice Act, commencing with the section 2168 of the Business and Professions Code, the board is authorized to issue a special faculty permit to a person who is deemed to be academically eminent under the provisions of the statute and meet the other eligibility requirements for issuance of a permit. This permit authorizes the holder to practice medicine only within the facility of the applicable medical school and any affiliated institutions in which the permit holder is providing instruction. So a review committee was created to review applications and make recommendations to the board on the approval of such permits. The review committee consisted of one representative from each of the 8 medical schools in California and 2 board members for a total of 10 members. So with that background, we had a teleconference meeting on September 15th to review 2 applications. Could Mr. Warden come forward, please? So Mr. Warden, as all of you know, is in charge of, is Chief of Licensing, and I would like to review the first applicant, give you a brief overview of that person. The first applicant is
Dr. Holmes.
Okay, Dr. Holmes. Okay, we're going to do that one first. Okay, hang on. So, can you summarize his background?
Dr. Holmes is a graduate from the University of Amsterdam in 1993. He's completed several residencies and fellowships between 1990 and 2002. He is considered an expert in digestive diseases, and he is also a leader in the research of specific stem cell research regarding digestive diseases. He's been UCLA's David Giffen School of Medicine is requesting that he be appointed to their new facility of which is going into the digestive disease research for stem cells, and he will be the only doctor in the United States that has that expertise that they've been able to recruit. So they are looking forward to him coming and being an integral part of their system regarding providing new care methods to patients in California and throughout the United States.
Okay, so I'd like to, he clearly is one of the preeminent experts in inflammatory bowel disease, and he has very special database software that will be able to help the institution significantly. UCLA is building an institute for him, as I understand it. And so I would like to have a motion to approve this candidate.
So would you like to be the maker of the motion, sir? Dr. Loeb, you can make the motion.
Okay, sure. I move that we approve this candidate's application.
Second, do I have Dr. Levine? Second?
Well, either of us.
Okay. Dr. Salmonson, second. Do I have any discussion on the motion? Any questions on the motion? Any public comment on the motion? All those in favor of the motion, please say aye.
Aye. Aye.
Any opposed? Thank you. That's done. Continue, please.
Okay, the second candidate is George Weiselthaler, and he is a cardiac transplant surgeon, and UC San Francisco has requested that we consider this gentleman. Kurt, can you give us an overview of his qualifications?
Okay, he is a graduate of the University of Vienna in Austria. And he graduated in 1987. He's completed several residencies and programs and fellowships in cardiology and the vascular surgery. Between 1988 and 2007, he was the head of the surgery department in the military hospital in Vienna from 1988 to 1989. His expertise is expertise is highly regarded in the United States. He's been a visiting fellow at the University of Baylor College of Medicine in Texas, Milton Hershey Medical Center in Pennsylvania, Columbia Medical Center in New York, Cleveland Clinic in Ohio, and along with the Ottawa Heart Center in Canada. He's completed advanced fellowships in Austria, working with the surgeons at the St. Paulin Hospital. He is a leading trainer of heart and lung transplants in Vienna, and they are requesting that he be appointed to their facility.
Would you like to make the motion, Dr. Loeb?
Yes, I move that we approve the application of Dr. Weiselthaler.
Second.
Any questions? Any public comment? All those in favor, please say aye.
Aye.
Any opposed? Thank you very much.
And finally, I'd like to ask the licensing committee chair to appoint a licensing subcommittee of one physician member to work with the staff and legal counsel to research the need for a more defined special faculty permit application and to revise the required supporting documentation, including the possible needs to update the regulation. So the purpose of this is that we approve these physicians, but we have no follow-up on what happens after them. And I think that as a board, we have some responsibility to track to see how these people are actually doing. I mean, it doesn't seem like it would be difficult, and it's something that we don't presently do.
Dr. Levine?
Are these time-limited appointments? I mean, do they have to be renewed at some point? Or?
They do not.
They are renewed every 2 years. They're renewed like a regular physician
license, right.
Unlike the special programs, the other special programs, however, this does not have a 5-year limit or a length of time that you can hold the permit. It is at essentially the school's discretion,
And
because you have to be at a school.
And I'm sorry, this is only limited, that license is only limited to the
Specific site.
Specific to the specific site. They
location.
can't go and practice
No.
anywhere else. in
And
California.
affiliated institutions.
Oh.
So do you need a motion for a subcommittee? I don't think so. I think
No,
we'll
I
just take
don't.
it
No,
under
we just need the
advisement.
licensing subcommittee chair to appoint somebody.
Okay, that's a good idea. That'll happen. Thank you very much. You have one more. Continue. You have a Stanford University discussion?
Oh, yes. Stanford University School of Medicine has requested to change their special faculty permit review committee member from Dr. Lawrence Schur to Dr. Clarence Braddock, who's the Associate Dean of Graduate Medical Affairs. So I'd like to make a motion that we approve this change.
So you're making that as a motion, correct?
Yes.
Second?
Second.
Okay, is there any questions from the board? Is there any public comment? All those in favor, please say aye.
Aye.
Any opposed? The motion carries. Thank you very much. Dr. Lowe, thank you. Dr. Salmonson, would you please present the licensing committee update?
Yes, thank you. Licensing committee met yesterday, and the two main issues where we had presentations from Mr. Warden and Ms. Osito regarding international medical graduates. The first part of the presentation was on their process through the license application process, and the second presentation was on international medical schools, designation, and recognition. And we had clarification of some international lists that are in existence, but that these lists, specifically one by the World Health Organization, now managed in Copenhagen, is not the same as recognition or accreditation. And in fact, the other important part of the licensing and board's responsibility is that they are now going to go through all of the international medical schools that we currently acknowledge and go through the reapplication process or revision of their accreditation. So because that is, correct me, Anita, time limited, how long? So it's 7 years, is it, that we need to look at?
The regulations require that the board reevaluate recognized schools every 7 years.
Correct. So there is a process in place. That's been discussed before, unfortunately, with other pressures on the licensing department that perhaps is really now timely that we must get on with that, because apparently there are a number of schools that are on that timeline. And those were the main issues. Just as an aside, I do think that I think it's important for students that are applying to medical schools to know in advance the ones that we do accredit, because apparently, according to Dr. Warden, there has been some confusion on the part of students, but there are some students who will take a chance and go ahead and hope their school will be accredited, but at least they should know in advance what the status of their school is.
Thank you, Dr. Solomonson. We're going to move on to number 9, item number 9, and Ms. Whitney, our Executive Director, is going to make a report in absence of Ms. Chang.
Since Ms. Chang is unable to be with us today, I would like to provide her update, and I would like to share with the board some of the activities staff has been engaged in with the Federation. Ms. Chang will continue to report to you on the license portability pilot project that includes 10 states. The American Board of Medical Specialties is working on its maintenance of certificate program in collaboration with the FSMB. The Board of Directors at FSMB is revising and updating its policy statements to be voted on at the April House of Delegates meeting. Board staff has received the draft Reentry to Practice report that will be presented at the April meeting of the Federation. I have assigned a medical consultant to assist staff with its review of this document so we may transmit our comments by December 12th to the Federation. We have been contacted by the Federation regarding attendance every 3 years at a board meeting. Liaison Director to the Medical Board of California, Dr. Ram Krishna of the Arizona Board, and Dr. Hank Chadre, President and CEO of the Federation, agreed to attend the May 2012 meeting in Los Angeles. This will be immediately following the annual Federation meeting, thus they will be able to provide members with an update on that meeting and resolutions passed. This will be the time for an update per the request of Dr. Levine on the maintenance of licensure issue. On October 20th, staff participated in a roundtable sponsored by the Federation with the Education Commission for Foreign Medical Graduates, ECFMG, regarding its plan to require all international medical schools to be accredited by 2023. We will monitor this closely and work with the ECFMG as needed. The Federation is accepting nominations for the Board of Directors and Nominating Committee. I have not heard from any of our current board members regarding a wish to be nominated for these elected positions. With that, then, we don't need to submit any nominations. On November 9th and 10th, the Federation is sponsoring a board attorney workshop in Florida. We submitted an out-of-state request for Kurt Hepler to attend. Unfortunately, this was denied by the department as we have a travel freeze. On October 13th, the new state policy and government relations associate of the Federation contacted us to share her primary task and offer assistance in tracking federal and other state legislation. And she and Ms. Simones will be working closely together. Per request from Ms. Shipsky, I contacted the Federation regarding the collection processing times for applications and licensure. They do not actually collect the processing time, but referred us to the composite requirements and statistics for 2012, which has just been released. And also, they suggested that we post a question. So that was posted to the board executive directors through the administrators in medicine. And when we have the staff resources in the next 2 quarters, we will summarize all of that data as well as the data in the book to provide that answer back to you, Ms. Shipsky. We've received a draft report examining the metrics that are used by the Federation related to the composite action report. That will be presented again at the April Federation meeting. I will be assigning a medical consultant to assist staff with its review of the document, and we will transmit our comments by the due date of December 15th. And that concludes what we're working on with the Federation.
Thank you very much. Are there any questions of Ms. Whitney on her report? Thank you for doing that for Ms. Chang. We're going to move on to the Health Professions Educational Foundation update, and I'm going to go first, and Shelton, if you have anything, Dr. Dussault, to add, please feel free. We had a board meeting, a Board of Trustees meeting in the fall, and we are moving in a direction of trying to assess and realize our mission-critical functions as far as demographically handling what we're doing out there. We had a meeting as well for the Stephen Thompson Loan Repayment Program, and this board and the public should be well aware of the fact that we have presented 76 awards on the loan repayment program, of which that translates to $8,053,000. We had an opportunity for a matched program with some leftover money from the federal government, so that was almost $3 million that we put to good use. So with the $4 million and the $3 million approximately, it's up to $8 million. We should all be very pleased and proud that we've got 76 doctors serving underserved communities throughout the state of California, which through the leadership of this board and CMA and all those others, including Dr. Getnick, made happen. Dr. Dussault, do you want to add anything? Okay, thank you. We'll move on the agenda. Number 11, I don't have any interested parties that I've been meeting with other than anyone I meet with is very interesting. But trust me. So as far as the President's report, I would like to thank our presenters from yesterday, Drs. Sutures and Greenberg, who provided a very informative session on the diagnosis of substance use disorders, I guess, and determining when a physician is safe to practice. Sorry. During this quarter, I attended a meeting with the agency's secretary, director of DCA, our executive director, and the chief of enforcement regarding enforcement program and the public citizen letter and allegations. The staff at the board has been working on an examination of that data mentioned in the report. Although 2/3 of the data was old and has passed the statute of limitations and has been purged due to retention requirements. We have a follow-up meeting with the governor's office and staff with the AG on November 9th, and we continue to have our weekly calls. I meet with the staff every week, as well as monthly. We have a call with the Director of Consumer Affairs and all executive officers and the board chairs. The issues that are covered basically are travel restrictions, hiring freezes, appointments or lack thereof that are being made to the boards, and whatever updates is effective for, or that we all should know about. Our next conference call is December 8th. Where hopefully we get more information than we had last time, which is nothing has changed. So we're still under freeze restrictions, still under travel restrictions, still under no new additions or appointments to the board, and it is what it is. So I would also like to mention that there was a community-based free clinic in Los Angeles County this past couple weeks. It seemed to have gone much smoother than the others have gone in the past. There seemed to have been a lot more coordination between community-based clinics, so there was more opportunity of sharing of records and electronic records that are going to be going forward, as well as follow-up appointments. So some of the issues that have been of concern under the RAM, which was the model that they used in the name of the organization before, people from RAM are not in charge anymore. There's a new division called California Care or Community Care. I'm not sure exactly. Some of the people from RAM and some new people are going forward, and they seem to have made a big difference with approximately 5,000 people. So that's the report from that information. If anyone is interested in more information on that, I have that available. So move along to the Executive Director's report. Ms. Whitney.
Thank you. I'd like to start with an update on staffing and take a few minutes to recognize those staff who are working exceptionally hard right now, carrying the workload of 2 and 3 jobs. Starting with our enforcement supervisor 2s, who are covering the supervision duties of the various offices, as we have 4 vacancies. They are doing an outstanding job under the leadership of Ms. Threadgill and Ms. Sweet. We're keeping the workload moving and not letting the timeline slip. We have 4 supervisors in licensing, each carrying at least the workload of 1 staff assignment in addition to the supervisory duties. As an example, Cindy, could you please stand up? Cindy is doing the international work and review of the most complicated licensing cases while assisting Kurt with the licensing committee presentation, in addition to her normal supervisorial duties. Thank you, Cindy, and the rest of the supervisors in licensing. The call center, cashiering, and the front end in licensing, and the front end are those folks who put together the licensing files, have been short of staff for over 3 months. Actually, it's closer to 4 now. All licensing staff, knowing the critical need to get the work done, has jumped in to ensure the calls are answered, the money is cashiered, and the files and mail are delivered to the applicant review analyst in a timely fashion. All this is made possible by the exceptional leadership skills and respect held for Mr. Warden. Today is our first meeting without our former sound engineer, and I would like everyone to acknowledge the hard work of our business service staff who has put this meeting together while covering the needs of all of the staff back at headquarters and our field offices, even with 2 vacancies. Thank you. Our information system shop not only makes the computer system function well, but provides our flash drives and web updates for you at this meeting. We have begun an intensive few months of work on the Breeze computer system and conversion of our email systems. We have 3 information system staff who work almost full-time at the department in order to get these computer systems up and running. And we have analysts from all of the units of the board working to ensure that the computer system is programmed, tested, and operational for fall 2012. They're doing a tremendous job, and this is on top of their normal work activities. It's just amazing what staff is doing. Ms. Simoes has taken on the Public Information Officer position while working the legislative session with great success this year, getting all 3 of the board-sponsored bills signed. Last, we need to acknowledge Cheryl Thompson. Cheryl has been working her administrative assignment along with her licensing and midwifery staff assignments. She is the best organized person I have ever met. She keeps the executive office running while providing excellent customer service. And with that, on her behalf, I would like to encourage the board members to return your travel and your per diem forms as soon as possible. You'll make her life a little bit easier so we can get that done. Moving on to administrative matters, and again, the staff at the board is exceptional, and I would like to give them all a hand. On administrative matters, I participated in the administrators in Madison, Western, and Central Regional meeting, where executive directors from about 20 licensing agencies discussed successes and issues related to how we review, prioritize, and evaluate cases, including the most likely cases to lead to discipline. It was a very informative discussion. Ms. Threadgill, Ms. Katie, and I met with the presiding judges of the Office of Administrative Hearings to inform them of our strategic planning process, when the vertical enforcement prosecution report is due, which is March of 2012, and when we will begin the sunset review process. We discussed training needs per the government code, relicensure issues, and international medical school issues. We covered new laws that will be effective in January 2012, and enforcement covered a number of issues that Ms. Threadgill will mention later on in her report. We are sending some of those judges and some of the deputies from the Attorney General's office to the Coalition for Physician Enhancement Conference. It will be discussing the impact of aging on physician clinical performance and quality of care. The individuals attending will in turn provide this information to their staff. So it's kind of a training, and then they'll train the staff that was not able to attend. We have begun examining statistics for the evaluation of the vertical enforcement process. We were provided some data from the Attorney General, but it was not prepared in the same manner as ours. Thus, we will be, that would make us compare apples to oranges. So we're still working with them on this issue and hope to have it resolved by the middle of November. I've been in contact with the branch manager of policy and research at the National Practitioners Data Bank regarding coming to California to provide training to staff regarding requirements and other services. He has asked us to include other licensing agencies, which we're very agreeable to do if his agency can actually come to Sacramento. Otherwise, we will be looking at a webinar that might be available for training of staff. As you heard from Ms. Yaroslavsky, there's a meeting that's scheduled for November 9th with staff at the Governor's Office, the Attorney General, Consumer Affairs, and the Medical Board regarding the enforcement program and its timelines. Mr. Warden and I met with the graduate medical education deans of the UC campuses to discuss various licensing issues and to update each of them on what the board is doing in licensing. Our next quarterly meeting is scheduled for February. The department has provided its implementation memo on the requirements for the expert reviewer contracts. We will be reviewing these guidelines to determine the impact on timelines for enforcement, and we will be able to report back to you at our February meeting. And per request from Dr. Lowe, we have asked the administrators in medicine to post a question to survey the boards regarding their use of faculty permits or similar programs related to the licensure laws. So we have a comprehensive report for the licensing committee. And that concludes my report on administrative matters.
Thank you. The budget overview, Ms. Kirchmeier, would you come forward, please?
Good morning. I would like to first bring to the members' attention a request from the Department of Consumer Affairs. On October 11th, we were informed that based upon the Financial Integrity and State Managers Accountability Act, known as FSMA, the department needs to identify and report the most significant risks in the department and implement a plan to reduce or mitigate those risks. The definition of a risk as defined by FSMA is defined as those objects or impediments that stand in the way of achieving your goals and objectives. The department has asked the board to identify the 3 highest risks the board is facing today, explain the probability and impact of each risk, and explain what steps have been taken to date to reduce or mitigate the risk. Ms. Whitney and I will meet next week to discuss and provide a response to the department on those issues. In addition, we also responded to a request from the State Personnel Board via the Department of Consumer Affairs regarding the translation of our documents and forms, including those on our website. The State Personnel Board had identified a deficiency in the Spanish translated documents based on the board's reporting on the required biennial language survey. The State Personnel Board wanted to know what documents we had translated and our plan for translating any other documents into Spanish. We identified all of the documents that we have translated into Spanish, including our complaint form, enforcement process brochures, tip sheets, and several other consumer pamphlets that we actually hand out in those languages. However, we did indicate that the forms specific to applicants and licensees would not be translated since those individuals must speak English to take the licensing examination and therefore would be required to be able to complete our forms in English. Then on Monday, October 24th, we were contacted by Senate Pro Tem Darrell Steinberg's office with a similar request. According to the Pro Tem staff, they are gathering information about the availability of multilingual services in various sectors of state government. They asked questions regarding the languages that are available when we perform outreach, the translation of applications, if our examination is given in other languages, what type of consumer services the board offers in other languages, in addition to several other questions. We will be putting together a response for Senator Steinberg's office next week, and will also include all the languages spoken by investigative staff that we have in the past, who have made presentations at ethnic organizations during their outreach programs. Okay, without any other questions, I'm going to be moving on to some staffing updates. At the last meeting, I reported the board had 58 vacancies, including the CPEI, or Consumer Protection Enforcement Initiative positions. At the end of October, the board will have 71 vacancies, including those positions. This number does not include 2 future vacancies that would occur due to retirements or staffing transfers. Actually, I need to make that 3, I found out just recently. And 71 vacancies equates to a 25% vacancy rate for this board. We are still allowed to hire individuals within the board and from the Department of Consumer Affairs. However, we are still required to request freeze exemptions to fill any positions with individuals outside of the board or the department. The board has submitted 11 freeze exemptions to the Department of Consumer Affairs. 5 of those freeze exemptions have been approved by the governor's office, including medical consultants in licensing and enforcement, 4 supervising investigators, 5 investigators, and probably the most important, especially based on what Ms. Whitney just said, is that on October 20th, we received approval for 6 office technicians in the licensing unit. So those front end, those cashiering, and this consumer information unit individuals, we will be able to hire 6 individuals to fill those positions. And we have begun already the hiring and recruitment for those positions. 3 of our freeze exemptions, one for the public information officer, we have 3 associate governmental program analyst positions in the licensing program, and an administrative assistant in our executive office have been approved by the department and the State and Consumer Services Agency, but they're currently pending at the Department of Finance prior to their approval and then submission to the governor's office.
Question, Dr. Solomon?
2 things. One, what is the vacancy rate, if you know, in the other departments? Like, what are our chances, since we have to hire within DCA, to strip other departments? Not that I'm opposed to doing that, of course.
Right. It's kind of a two-pronged question. The first, when I left the department, there were some boards that were hitting the 20% as well. I don't know, our board at 25 is the highest that I've heard of. I've heard of 23%, but that was, again, at least 2.5 months ago. Though on our calls, I know that we've heard a lot of individuals in the same position waiting for their freeze approvals.
If I may, one of the items that Dr. Lowe brought up was the vacancy in the physician assistant program. That program is fairly small, so one vacancy is a major impact to them. We have a few more people who can cover different areas than a small agency like physician assistant or occupational therapy. So although we have a high vacancy rate, we have a little more flexibility, but it still doesn't keep the pain down.
Mm-hmm. And I guess just that dichotomy of, we have what looks like by statute an illegal amount of reserve, yet, I mean, how do we deal with that, I guess, with the public?
No, you're either authorized to spend the money or you're not. It's the money's there, but
you know,
yeah.
I think
that's why I'm asking the questions.
You know, that dichotomy and how that gets answered when people ask. I mean, I don't say anything, I just say, I don't know, but people do ask.
The question should be asked to the right individual that can therefore hear the question. But Dr. Drousseau?
Yeah, if this situation continues, and it looks like it will, because this is what we've been discussing for some time now, perhaps at some point we might have a discussion on the impacts they're having on the operation. And I know from all of what I'm hearing is that the staff is working enormously hard, and I suspect that we'll have some burnout effects on that as well. And I don't quite know how long a staff can keep this kind of thing up without burnout or sort of getting behind in the work. And what might that work be that we might get behind in, which could be very critical to the operation of this board?
As you heard from Dr. Solomonson, we are not doing very much related to the reexamination of our international medical schools. We have had to push that out into the future because we do not have the analytical staff to spend time on that particular issue, including the evaluation of new international medical schools, and Mr. Warden will be presenting material on that. It's a much slower process than maybe it needs to be if we were fully staffed. So we've had to transition staff from doing that. We also have implemented some volunteer overtime, so we can ensure that our licensing applications are reviewed in a timely manner. In terms of enforcement, Ms. Threadgill has informed this board that we've had to make adjustments in the complaint section and how we triage complaints related to certain types of complaints that are coming in, not the quality of care, but some of the other complaints. So we've had to make do what we needed to do. In addition, we had to cancel our Midwifery Advisory Council. Our last meeting, our next meeting is coming up in December, but the quality of staff work could be impacted significantly because we cannot spend the quality time that we need to on those particular issues. And those are just some of the items that are outstanding.
Thank you.
Do you have any other questions? Ms. Shipsky?
Madam Chair, I'm wondering if in light of the discussion, and I know this is a continuous discussion that we have almost every meeting, that it may not be appropriate at this point, or it is appropriate at this point that the board direct U.S. President to either in correspondence or by direct contact both the Secretary and the Governor. I mean, we're at a point, this department is funded by licensee fees. This is not general revenue. It's never made any sense to me why a department like this would be subject to the same cuts and reductions as departments that come under general revenue tax funds. If we cannot, in fact, through staff, perform the functions for which the license fees have been paid, then we are going to be subject once again to, I think, public scrutiny, but public comment about the board. And I think that it's gone beyond, you know, we can talk about the impact, and I know staff is doing everything it can, and it is burned out. But also I think we need to address the restriction about only be able to recruit from within, because that has caused a burnout cycle within a particular, area, and that particularly like for enforcement and investigation and things of that nature, where there are a number of people in the outside industry that could add certainly new blood, new perspective, but also are readily available for this kind of work. So I will defer to council, but my understanding is because this topic is on the agenda and we are discussing the impact of lack of staff and cuts and things of that nature, that we could perhaps maybe take some kind of action today, requesting that the chair, either again by letter or by direct contact, make this information known and our concerns known both to the Secretary and to the Governor. Would that be permissible?
Yes.
Yeah, we could do that. So I'd like to make that motion, if I could. I think you should do both, Madam Chair. I think we should have a letter, and I think we should also have you personally contact those two individuals. And I know, as being an appointee of the Senate Rules Committee, I know that Senator Steinberg and his staff have been watching what's going on, and in light of the fact that the LA Times articles are not pleased. So I would hope that, if we have to CC both the Speaker and the Senate Pro Tem, the President of the Senate, we need to do so as well. I just think it's gone beyond a point where, we can commiserate with staff. The reason we've been appointed is to be able to carry out the requirements of the California Medical Board, and I don't think we can do that if we don't have appropriate staff.
I thank you for that, Ms. Shipsky. In light of that, I just want you all to know that I never miss an opportunity to miss an opportunity. So I've had...
So we can have, if I can get a second.
Oh, you can have a motion on the floor. Do you have a second to the
So
motion?
move.
Second, yeah.
Second, okay. So let me have some, I'm happy to call the vote and to move forward with a letter or face-to-face, but I just want you all to know that I've had direct communication with Darrell Steinberg, the President Pro Tem of the Senate, and with John Perez, the Speaker of the California State Assembly, as well as Governor's staff they understand real well the situation. I've had various conversations with legislators as well to remind them that this is a specially funded board, but many of the healthcare provided boards are the same. And the argument of how to do a budget doesn't get you points when you can't make the point. And it's easy to include everyone in the sweeping up of what needs to happen versus separating out. So maybe a letter at this point would be a good idea. And I know that they have heard from me.
Madam Chair, I think also stressing, in that context that we are bringing this to the attention of these people because of our concern about public protection. You cannot function and you cannot accomplish what you are required by law to do, and that is to protect the public if we in fact don't have sufficient staff to do that. And so I would think that has to be stressed in the...
Absolutely. So a letter will be drafted and sent, and it will be brought again to their...
You haven't taken a vote on it.
Oh, sorry. All those in favor of Ms. Shipsky's motion?
Discussion?
I just wanted to speak in favor of the motion strongly.
Sorry.
Both as a member of the board and as a physician, because I get it in two ways from the colleagues. One, they see issues like the Operation Safe Medicine, which we were kind of pushing and then kind of had to unavoidably gear back a bit. The other thing is the misperception that we've got insufficient funds because physicians don't want to pay higher licensing fees, when in fact the surplus exists, which we can't touch. So we kind of get a double-barreled thing, which, again, I can't explain and say, tell your legislature, But anything that we can do, because public protection, I mean, to kind of go at it from the exemption point of view, if they don't want to do it because we're a separate fund, but that just like the police department, that we are trying to protect people from unsafe practices, and if there's any sort of adjustment that has to be made in enforcement because they're not fully staffed, I think that's of paramount importance.
Thank you. Is any, Dr. Levine?
Yeah, another piece of data that would be, I think, helpful to understand the impact of this is turnover rates in each of the areas. Turnover is disruptive, and moving people in and out adds an additional level of texture to the vacancy rate.
And I can tell you that just within our licensing unit, because those individuals right now, actually in our U.S., they're all new. So we have a lot of, learning curve as well in all of our positions. So we can look at that.
Any other comments from the board? Do I have any public comment? I just want to remind the public sitting in the audience, public listening, that you also have a voice in this. That if you're not happy with what you see going on and you hear at every meeting that we have, you are free to contact your elected representatives as well as the governor's office and tell them how you feel about this. And you might have more voice than I do. I don't know, but you can try. Public comment. Karen, would you like to come forward, and afterward you'll fill out a slip, please.
Karen Ehrlich, Midwifery Advisory Council. I just wanted to suggest that a copy of that letter also go to the LA Times.
Okay, so we've had the motion, we've had the public comment. All those in favor of the motion have we voted? All those in favor of the motion, please say aye.
Aye.
Any opposed? Okay, so it'll be done. Thank you very much. Continue, please, with your report.
Moving on with travel freeze update. As of today, the board is still under the travel freeze. For the most part, any travel that requires the submission of a travel expense claim must be approved by the Department of Consumer Affairs. We have been able to receive approval for most of our trips, but it is an additional workload to submit those requests to the department. There has not been any information regarding when or if this freeze will be lifted at this time. Then moving on to the budget update. If you will turn in your packets to tab 13, you will find the budget reports on pages 114 through 121. On page 114, it shows the most recent fund condition for the board. And this kind of will speak to Dr. Solomonson's issues earlier. On this document, you will see that we are anticipating costs due to the reestablishment of the Operation Safe Medicine Unit, the BREEZE project, and also the cost for accepting payments via credit card. As some of you may remember, the board was audited by the Bureau of State Audits in 2007. At that time, the board's fund was over the mandated 2-month level of reserve, and the Bureau recommended that the board consider reducing licensing fees in order to not exceed its mandate. Since that audit, the board has sponsored legislation that moved the mandate from 2 months to in between 4 and 5 months, 2 and 4 months reserve. The Bureau continues to yearly follow up on the implementation of the recommendation, and on September 28th of 2011, the board received a letter from the Bureau requesting the status of the recommendation. The board responded to the Bureau with the attached fund condition, indicating that at this time the board is projected to be at the mandated level at the end of fiscal year 2011-2012 and projected to be even lower in the following fiscal years. This is due in part to several items, including the $9 million loan to the general fund and also the anticipated costs that I previously mentioned. It would not be prudent for the board to consider a reduction at this time. As you can see from the fund condition on page 114, although the board was at a 6.7-month reserve at the end of this past fiscal year, we are projecting to be at 4 months at the end of this fiscal year and projecting to drop to 1.5 months reserve in the fiscal year 13-14. The large increase in the reserve last year had to do with the hiring freeze, the inability to hire staff, and therefore the large vacancy rate, as well as the inability to travel and make purchases for large items such as vehicles. We will revisit this discussion at the end of this fiscal year when we have a better idea of this year's spending and any other items that may impact the board's fund condition. Yes?
A question on the fund condition, page 114. It shows that we're going down to a very low number in the years 2014-15. My question is that what are we mandated, what are we allowed to keep versus what we are going to need to keep?
We are mandated to keep between 2 and 4 months in our reserve.
So 2 to 4 months is at what? We're not making that come next year. 213,
right.
214, 214, 215.
Yeah, 214 and 215. As most of you know, this is a revolving document. It's an ever-changing document. We will determine at the end of this fiscal year how much money we spent, and that will have an impact. We look at this at the end of every fiscal year to identify where we are in the future and if there's any need for amendments or changes.
It's a flux number.
Yes.
Okay. And if I may, real quick, if we do get down to the 1.5 or the 0.1, then the administration would need to address the return of the loan money in some levels to come back into our fund. We would not be looking at increasing fees. We would be looking at return of part of the loan money.
But, okay, so my understanding is that there is already an agreement as to the money coming back. Is that, am I hearing something different now?
No, it's coming back in the future. We just don't know when that future is. So if we came to a point where our fund condition was going to be 1.5, then we could make a request of the administration to have some of the loan returned. There's not a set date on when that loan will be returned.
When the money was taken and used from the fund, my understanding was it was done under the assumption that it would be returned at a specific date. And that is not correct? Is that what I'm hearing?
The Budget Act didn't specify a date, and it just said it would be returned with interest.
And it is when the board needs it. So when we would
and actually some boards have had some of their money returned due to their fund condition being very low.
So if we don't show a need, the money doesn't come back? The money's wasn't public money to take to start with? Mm-hmm. I'm looking at some faces out there and I'm not seeing any.
It will come back based upon a need. Okay. That's when, at this point in time, but there may be some point in the future where the administration makes a different determination should the resources of the state be very healthy again.
Okay, thank you. Dr. Levine?
What is the cumulative amount of loans to the general fund?
It's currently $15 million, I believe.
From this board?
From this board, yes.
Any other questions? Okay.
What's the interest rate? You said it was going to be returned at interest. Is that
the same that Buffett gets from Bank of America?
I would have to check on that and get back with you. I know
No, seriously, all kidding aside, I'd like to know if that has been specified. I mean, that was exactly my question when you were saying you're going to get down to 1.5 months. Was that calculating the loan repayment? And apparently...
I thought it was a 3-year borrow.
And it would probably be the same as what the interest rate is on the money that we currently have in our, what we would be making in our bank account, because all the money is pooled money for the state, and it does all go into one account, and then they look at that based on that interest rate. So I would assume that it would be that same interest rate that we're currently getting on the money we have.
I don't mean to be facetious, but just to see what the terminology was when that money moved, because I can easily envision it being lost in the accounting department, and so I would be interested in what that document looked like when that money was transferred.
And it is, and I can tell you that just from my experience on the other side, but it will be returned, because I know with contractors they received their fund plus the interest, their loan plus the interest.
How long did that take to come back?
It's actually as soon as they found a need for it, which they did, they were going to have to raise their licensing fees, but before they could do that to their licensees, they actually had to go through the processes, and it's a quick process. It's
So
just
when is it we're going to be raising our fees? I didn't hear that answer to that question. No. I didn't understand.
But it's a vicious cycle, because we can't spend the money to demonstrate the need.
We need to raise our fees. Sorry, we're going to raise our fees out there.
Not going forward, Barbara.
I'm glad I'm so much joy today. Okay.
You are providing a bit of humor.
I know. So I'm going to move on to the next page, unless there are any other questions. Okay. The next page shows the entire board's actual expenditures as of August 31st. At this time, we're on target for this time of year, and that there's nothing in there that raises any concerns. It is interesting in looking, we do have, just as a bit of humor, we do have a new budget analyst, and she was very concerned this year because we had spent so much more than the prior years as of this time of the year. I had to explain to her that in the past we usually never had a budget. So usually the months of July and August were, pretty low, and then this year we do have a budget that was on time, so that was a good thing. We weren't exceeding our budget. The next 4 pages show the budget report specifically for licensing and enforcement and the AG expenditures for enforcement. On page 119, that shows the enforcement receipts received in the last 3 fiscal years, and then also as of August 31st. The next page, 120, shows the board members' expenditures through September 30th based upon the claims we have received from the members. And then the last page is a synopsis of the board's budget and the expenditures by each different program. Okay, so unless there's any questions on those pages, I'm going to move on to the Breeze update.
Oh, please.
Okay. Because the contract with Accenture was signed at the end of September, Ms. Whitney and I attended the Breeze launch event on Wednesday, October 26th. Secretary Caballero, Secretary for State and Consumer Services Agency, spoke at the event, as well as the Deputy Secretary from the California Technology Agency. The meeting was to introduce the project team and provide the boards and bureaus a demonstration of the system. It was a good presentation, and we're very excited for this new system. Due to the delay in the contract being signed, the project is about 1 month behind. However, we anticipate the system to be running by this time next year. Since the vendor is now on board, the medical board staff will need to become very involved to ensure that the systems meet our needs. We have 2 staff members from our Information Services Systems branch working at DCA on the project, one on a part-time basis and then one on a full-time basis in order to assist with the project. Additionally, we have had our core subject matter experts and managers attend meetings this week with the vendor in which a demonstration of the detailed system was presented. We have received the schedule for participation, and staff from the medical board will be required to attend system configuration interviews with the vendor beginning November 28th through December 7th. This is the most important part of this project, and it is very important for our staff to attend. However, with the freeze still being in place and having several vacancies, it will impact our board functions. As I stated last time, the most significant risk is still data conversion. The lack of staff also has a negative impact on this risk, as we need to have enough staff to clean the data once reports have been run showing data that must be updated prior to conversion. We will know more once the vendor has identified the mitigation on the data conversion. We know that the system is going to have significant improvement over our current processes, and we are glad we will be involved, but we also need to ensure that our day-to-day operations are being completed too. If necessary, we will be authorizing mission-critical overtime for employees to perform their core functions while they are involved in the BREEZE project. Are there any questions on that project? Okay, with that, that ends my report.
Thank you very much. Questions, Dr. Levine?
Could we take a 5-minute break?
I just read.
Good thinking, Dr. Levine.
We're going to take a 10-minute break. It's now 10:33, so we'll start back here 10 minutes hence, please. Oh, phew. Consideration of a modified text for polysomnographic technologist regulations. Mr. Warden and Mr. Hepler, please start your presentation.
Good morning, Madam Chairman and members. As you recall, the board has considered the implementation of the polysomnography program before. As you recall, one of the issues was the eligibility for registration. There was a concern that our initial regulations would have only grandfathered those persons who had been practicing polysomnography safely for 5 years from the examination requirement. The proponents of the measure thought that the grandfathering should apply to all the registration requirements, not just the examination requirements. However, the statute did not tilt in their favor, was a little bit vague in that matter. So these proponents of the measure took the opportunity to clarify in legislation that the grandfathering of the safe provision of safe practice of polysomnography for 5 years entitled the applicant for release from or waiver from everything. And so the board in this draft has taken advantage and modified its current regulations to conform to the statute. Correspondingly, we've also made changes to the work experience form and the application form so that they too conform to the change in the statute. So what you have before you is a third modified text, and the appropriate motion would be to approve this for the purposes of authorizing the executive officer to go out for 15 days and circulate that modified text for review, and then in the absence of any adverse comments, prepare the rulemaking file.
Can I make a technical addition to that?
Sure.
It would be technically what you need to do is to authorize the executive officer to adopt the regulations at the conclusion of the 15-day comment period if there are no adverse comments. I want to make sure the word adopt is in there.
Okay.
So do I have any motion?
So move.
Do I have a second? Second. Do I have any questions from the board? I have a public speaker's slip on this, please. David Gonzalez, would you come forward, please?
Yes, David Gonzalez on behalf of the California Sleep Society. We were the original sponsors of the legislation, Senate Bill 132. I'm here basically to provide supportive comments. We're very happy with the work that the board's done. We're very supportive of Ms. Whitney's work, Mr. Hepler's work, and Mrs. Simo's work of helping us to do this clarifying amendment to this regulation. And we look forward to the board on going forward with the registration process. And thank you for your work.
Thank you for your comments. Any other public comment? I see none. All those in favor of the motion, please say aye.
Aye.
Aye. Any opposed? So the motion, again, will read to authorize the executive director to adopt the regulations if there is no adverse comments within 15 days, okay?
If there are any adverse comments, those can come back before the board.
Right. Thank you very much. So now we'll move on to agenda item number 15. Mr. Warden, would you please continue and present your report on the licensing program? And take a deep breath in between sentences, please. I'm listening too fast today.
All right. So I'd like to start off by providing with an update on our new applications for the physicians, surgeons.
Can't hear you either.
I'd like to start with providing an update on the new license application for the physicians, surgeons. The staff have been working on that. There's a little team that works on that process, and they have developed the first full draft of the new license to be disseminated, which has currently been done, to the other licensing staff for comments and suggestions to see if where else we need some improvements. Once they've made those comments, it's going to come back to the managers, myself, and the executive staff to go through, and then legal for that to be gone through and approved. So we'll have that. We're on track for that to be coming very shortly. I hope to have maybe that done by the January of 2012. So, and that's very good considering our staffing levels. So. I'd like to start by saying that we, as you heard earlier today, we had a special faculty permit review committee meeting in September, and there were 2 applicants, and the board approved those applicants today, along with the change of member for one of the medical schools. We have a current specialty board application that's pending, and that's been we're still waiting on response from that applicant. They did ask for clarification. We provided that, and we are now waiting on their response for that. You just approved the modified regulations to be posted, and so we're moving on with that. As far as we'll now go into, I'd like to go into the staffing issues. One of the things I'd like to say is the staff has been doing an extremely outstanding job during this very tough time. Your managers are putting in lots of extra hours to make that all work for you. And that, on top of that, the staff themselves have been helping each other out. We're very short coverage. At some times, there's only 2 people in our call center. Okay, so we only have even though we just got those freeze exemptions, which will help alleviate that, but they have been working with 3 people, 2 people occasionally in that call center on a regular basis. Those are some of the things. Our U.S. application file reviewers, we have 8 positions designed for that. I have 2 experienced reviewers. One of those experienced reviewers has been out on leave. I have 4 new ones and 2 vacancies, and no applications for those vacancies.
Could you repeat that again, please, for everyone to hear again?
Okay. I have a total of 8 U.S. reviewer positions. I have 2 who are experienced, 1 who's been out on leave for a considerable length of time. I have 4 new staff in training and 2 vacancies, which I have no applications for.
Thank you.
Okay. We have 2.8 vacancies in our AGPAs, which is the result of one where I choose. We don't have, these are the positions that the managers and I do on top of our other work. That has to do with the application file reviews for seniors, international medical schools, policy and procedures, training. Those are all things that are not, they're being done, but not being done timely. So you need to understand that those are the positions we have a pending request for. I have on our international reviewers, we have a new vacancy that will be coming effective November 1st. That position's been advertised. We have been noticed that we're going to have another person out on medical leave for at least 2 months. So we have vacancies there. The staff's do once again more jobs, and they are doing a very good job in covering that, but it is very stressful for the staff. We also have just filled 2 of those international medical school positions, and those people are in training. That is a position that takes 6 to 9 months for those people to get fully trained. The U.S. file reviewers take approximately 6 months to get trained. Once we get our phone staff and our cashiering staff, and for the OTs, those all require training also. So we currently have 14.6 vacant positions in licensing, which is approximately a 6% vacancy rate for licensing.
Excuse me, 26%?
Yes. So, okay. So right now we have, I'll be going over a few of the statistics that are in your packet that start on page 124 and go through 130.
Yeah, I have a question on that.
Wait, could you, 1 second?
Did I understand that even when you had permission to hire, you weren't getting applicants? So in addition to not the freeze, the salaries aren't adequate? Are we looking at a twofold problem?
Well, for my U.S. reviewers, I don't have a freeze waiver for them. I am able to hire certain class people within DCA for that. But unfortunately, this last time that we just advertised, I do not have any applicants for that position.
So I guess that's what, yeah, so I mean, I see that as a problem, that even if you have permission to hire, you didn't get anyone who wanted to apply.
The pool is only from DCA employees, or the pool is broader?
DCA employees for
That's
those
why.
pools.
But that's why, okay.
Okay. So it's a limited pool, and some people do not want to move it, that classification, and it's also a classification that is not as widely used in some parts of DCA as other parts, and so it's a small recruitment pool, actually. So in the past, I steal from myself to fill those positions. So. Okay.
You can only rob Peter so often to pay Paul.
So that's one of the reasons why we have vacancies so high in different parts of like our call center stuff, because some of those people are eligible for that, and we can train those people.
Okay.
But that causes it's just like you said, not really filling your positions. You're just changing the vacancy.
If you were to take and elevate the position, what is the process to change the title? Is there a process in place in state government to allow for the increase in workload, to allow for a higher level of title, which would allow you to have different applicants applying?
Yes, there is that process. It's a rather lengthy process to justify a higher level classification when we've just justified this classification. But this classification is basically considered the entry classification into the analytical area. So once we begin to fill our 6 OT positions in cashiering, call center, and the front end, some of those will be eligible to apply for the licensing positions. So then we'll be able to backfill on the call center and cashiering and front end. So it will be a ongoing process, but there may be some qualified individuals that we find in the interviews that we have a freeze exemption for that will be able to place people into other positions.
Okay.
We're very hopeful.
Thank you. Continue, please.
Okay, so I'd like to, on page 124, your statistics, I did make an adjustment to match our annual report, and on that one, that was for the amount of applications received during the fiscal year of 10-11 from 5,914 to 6,047, which is an increase of 133 applications. And then also on page 127, there was an increase from the fictitious name permits for physicians and surgeons from 1,266 to 1,288. That was 22. There is a reason for some of that is when we run our reports, there are still some things that were pending in cashiering that showed up that didn't show up when I first ran them for our last board meeting. So that's the reason for that. For this quarter, the board received 1,711 physician surgeon applications, and we completed 1,491 initial reviews. So
that was back on page 124 that you just gave those numbers from?
Yes.
I've got it, Linda, but nobody else.
All right. Just want to make sure.
So I'll go on to that. On page 128 is the 5-year history of physician licenses issued, and on page 129 is the 5-year history of applications received. So, also, I'd like
Let me
to...
just ask you a question on that. On page 128, you're looking at licenses issued in the 5-year history. Am I looking at less applications currently?
Less applications
Well, I'm
currently.
looking at licenses issued.
What, licenses issued versus applications received? The licenses issued was actually how many licenses we issued that specific fiscal year.
So for quarter
page
number 4,
128.
in the middle graph, quarter number 4, looks like there are less licenses issued for the fourth quarter than there were in 1908-09. Is that correct? The dark line is shorter than the light line, correct?
Actually, yes, that was correct.
Is there a reason for that?
Well, the reason for that is how the applications fell throughout the year. So depending on when applications are received and licensed will change when the quarter got. We were in much better shape at the end of fourth quarter with being current and not having such a rush for some of the late applications. So it's based on the more even flow of applications coming in that meant for a more even flow of licensures issued.
So what we see is an obvious change in the numbers because of our outreach program that's being done by Mr. Shunke currently. Is that correct?
Correct.
Thank you.
So for our second level review of applications.
Excuse me, I'm sorry. I didn't
You're
see.
probably going to touch on that with that second level review. Because of that fact, what comes in and comes out the same month isn't the same kind of thing. What do you have the statistic? It's probably in here. The percentage of applicants that ultimately are deemed not suitable for licensure?
I do not have that in here. We do have currently 108 pending applications that we're looking at in the second review process, but I do not have that specific.
For the future, I think it'd be interesting to know if we're trending one way or another in that as well.
Okay. I'd like to, I emailed late sort of Wednesday night, so I don't know if you received it, the licensing statistics for the week prior, which is ended in October 22nd. We had received 169 new applications that week.
Wait, what page are you on?
I actually had emailed it to you. It's not there. The
Okay,
one that's in your packet is for the week before. So I'm going to give you...
the week before, we could add the numbers to it.
Right.
Okay, so the applications received were how many?
We received 169 versus the one that's in your packet shows 113. So these are the latest ones, and I got these just before I came down, so that's why they're not in your packet. So I wanted to give you some idea. We have in the week it's in your packet, we had 23 completed applications at the time of review. This past week, we only had 10. We reviewed 147 files for the week of October 15th, and we reviewed 126 for the week of October 23rd. The initial review dates for the U.S.-Canadian applications is 44 days that week, and it was 30 for the international grads. And our pending mail was at 7 days for each of those. Okay.
Wait 1 second, Ms. Whitney.
Dr. Solomonson, in our annual report, we list the number of actions we've taken on those who have applied for licensure, so we will summarize that in statistical form for you, but they are listed for prior fiscal years.
I figured it was in there somehow, but thank you.
It's in our annual report, not in this particular report.
So now I'd like to go ahead and move on to the status of international medical schools. I provided a much more detailed list this time. We're trying to give you a better idea of how much work is out there, and this list changes daily, weekly. And this list consists of applications that we've received for the International Self-Assessment Report, and also of those applications that we have received for physician and surgeon, either PTALs or licensure, who do not have schools that are listed on our list of recognized schools. And in this chart, you'll see that I have tried to, if I sort of have an idea of where the school might be based on the applications that we have, whether it's going to be probably a 1314.1 A1 school or a 1314.A2 school, we've identified that. We've also identified how many that we have pending and have either been recognized by the board or by myself and legal counsel based on 1314.A1. So currently there are 62 medical schools in pending status. Some of those medical schools are in pending status for a little while due to lack of staffing. Those are the ones. We have 2 specific ones that are waiting for a response back to them, which currently I'm the one that is preparing that. But based on the workload, it's been sort of delayed. So we will be working on that a little more to try to get them going for that. At the July board meeting, the board approved 1 school for recognition pursuant to 1314.A12. During this last quarter, 4 medical schools provided the necessary documentation to meet the requirements for recognition pursuant to 1314.A1, which are the government recognized schools or operated and owned by the government or a nonprofit that's primary purpose is for teaching the citizens of their country.
So let me ask you a question. In the workload that you've explained to us that staff is doing so much with, without physical bodies, and you see this report that's in front of us with some 60 schools that are pending, could that be something that we could hold up and say, we need money for this staffing? I mean, what I'm worried about is that everybody is doing everything, and you're getting everything done, but at the same time, it might be helpful if we could say to the powers of be that there's certain tasks, in fact, that can't be done because we don't have the staff. And if prioritization of jobs and workforce is a priority of this administration, then this is somewhere where we could use some help. So I'm going to look to you and our executive director in consort to be able to come up with some real...
This list and the next list that I will talk about are jobs that is one of our AGPA positions that we've requested freeze waiver for. So that's, we have nobody in that position, and the work is only being done by myself. Sometimes with the assistance of Ms. Oseto, and occasionally I borrow one of her staff members.
So what I'm hearing from you is that there is a freeze waiver in place for a person to do this job. There's a request that has not been approved, but is in the Department of Consumer Affairs, or is at the Department of Finance? So it's currently moved from the Department of Consumer Affairs. It's in the Department of Finance, so that when the meeting with the governor takes place next 2 weeks, whatever it takes place, this is an issue that we can say, help.
Yes.
We need a list, okay? Help list, okay?
Madam Chair, may I ask a question of Mr. Warden?
Yes, please.
Mr. Warden, given this list, it'd be my presumption that, given that the medical board does not go out and seek applications, that there's at least one applicant or more than one applicant behind each one of these schools. Is that correct?
Correct.
That's the issue. And when we prioritize the schools that need to be, I know that this is an alpha list, but at some point you're going to have to come up with a list that has it reversed, so that the number of applicants behind a school, more than one is going to have to take a priority of a school with one. I'm not suggesting that that's how we're going to do business, but it would be helpful to know how many are outstanding.
Okay.
Yep. Any questions on this specific international list of schools? Okay, continue, please. Oh, wait, Dr. Levine, please.
Yeah, question of information. So if the school is up for reevaluation, the school is presumed...
These schools are not recognized by us at all.
Okay.
These are new schools.
These are
so,
new.
So any student who applies to schools that have never been recognized are
hanging out there
at risk.
But we have the schools that are applying for, and within the 7 years have to be reconfirmed. Right. We have that group, and we have new groups.
Right.
The students that are out there, I'm not suggesting they should have precedence one way or the other, but there are two scopes of work out there.
So the question about the schools that are up for reevaluation and are either due or post-due, past due for that,
right?
Are the schools deemed recognized until the reevaluation?
Yes.
Okay.
And I guess just as another point of clarification, when we talk about students, there are students outside of the state who are trying to get licensed to the state, and there are students inside the state. And will we prioritize those who are already within the state?
Well,
they're in postgraduate training here. And
none of these are eligible for postgraduate training that's on this list because they're not at a recognized school.
And there's at least one applicant behind each one of these schools on the list.
But they're not. But do we know if those applicants are trying? I mean, they're not. So they're not in residency. I see what you're saying.
Right. They're not in residency and
Yeah.
they're not eligible for licensure. So some of these applicants are trying to become eligible to apply to the match for residency in California, and some are trying to obtain licensure depending on what state they're in and may already have license in another state, and may have already completed postgraduate training in another state.
So there's no one within our residency programs in California that would be affected from this?
No,
67
not on
list.
these.
Okay.
No, but so there's two sections within the within tab 15. There's the section of international medical school reviews that are up for review because they've not been reviewed yet, but there is a student behind each school. Then behind the next blue sheet, starting on page 130.8, there's a reevaluation of and a timeline of those schools that are up for reevaluation. Is that correct?
Correct.
And when you do the statistics in the future, you might want to have for the next 5 years, so we know what the workload's going to look like. So that schools are due the 10th. What about schools that are due the 12th?
I have, of all the schools that we have recognized, they're all here.
Oh, they're all there. I didn't see the second page. I'm sorry. Okay, so we all see that in the
And that is the work that is not being done at this point in time.
That's what I want to make sure.
I'm not doing anything on that list at all.
Yeah, well, that's fine. I just want to make sure what we're not doing is fine. Sometimes what you're not doing is sometimes more important than what you are doing.
So, sorry. So that's basically, this is an area that we are not doing well due to staffing.
Correct.
So, and that's my choice. I made that choice. So,
good choice.
That concludes my report, unless you have any other questions.
Do you have any other questions from any of the members? Any public questions? Okay, thank you very much, Mr. Warden. You're doing an admirable job, as always. Mr. Shumke, would you please come forward and do your licensing outreach report?
Good morning, members. Just to bring you up to speed from what's happened since the last meeting, if you'll remember during the last hours of the meeting in July in Sacramento, Ms. Kirkmeyer did advise you that I had received an authorization to continue with my licensing outreach program. That authorization and exemption from the travel restrictions was granted. So I would like to thank each of you individually, and Ms. Whitney and Ms. Kirkmeyer for offering your assistance and your encouragement to the department, to the agency, and to the governor's office in attempting to have those travel restrictions lifted. I have been continuing with my outreach. Immediately after the last board meeting, I traveled down to UCSD. I've traveled extensively throughout Southern California, Northern California, and the Bay Area. A couple of weeks ago, I spent 3 consecutive days in the Los Angeles area. Last week, I was at UC Irvine for a full day. And on Wednesday of next week, if any of you in the Los Angeles area would be available, I'll be spending the day at Kaiser Permanente, Los Angeles, from 10 in the morning until 6:30, 9 in the morning till 6:30 in the evening.
Which Kaiser? Kaiser Sunset?
The main facility, yes, the main facility on the corner of Sunset and Vermont.
Every patient who's a Kaiser patient feels that theirs is the main facility. So I just want you to know.
I recognize that, and
And I would venture to say that every Kaiser facility in its own entity is its own entity. So.
That is correct. So. Thank you. So now that
I'm not a Kaiser patient.
So now that the calendar year draws to a close, within the next week or so, I will be sitting down with Ms. Whitney and with Ms. Kirkmeyer. I've already received several requests for licensing outreach visits and licensing fairs for 2012. And we need to get a better understanding of what my ability to continue this program will be. Kaiser Northern California in Oakland has already contacted me, UCSD. I already have tentatively scheduled several outreach visits throughout Northern California and Southern California, with them understanding that the travel has not been approved yet, but we're hoping it will. And when I return to the office next week, I'll be sitting down with Mr. Warden and his staff to start our trek towards the July 1 licensing deadline of next year, collecting the names, whether we continue with the matrix or have been able to identify a better process so that we can hopefully repeat the success in which the licensing staff accomplished last year. There was no overtime by the staff. Of course, the managers pitched in tremendously, Mr. Warden and his managers. The majority of people were licensed in time. I can't tell you how positive the feedback is for the licensing staff. Recently, I talked to one resident whose husband was licensed 2 or 3 years ago, and she came to me with a very, very long face and very frustrated that her husband had told her it took him 5 months simply to conduct the initial review of the file. And with the statistics that Mr. Warden just shared with you in his presentation, I was able to tell her that right now we're running around 42 days for the initial review of a file. And she couldn't believe that degree of improvement has been recognized in our licensing program. So I'm still receiving kudos, compliments, and gold stars and everything else for the entire licensing staff.
Great.
So, any questions from you?
Dr. Salmonson?
Well, I mean, with the matrix being such a success, other than possibly some tweaking, what possible alternative would you think?
Probably none, but I just, we're always open to new ideas and new ways of doing things. But this is the time of year where we normally reach out to all of the teaching hospitals. We are able to access the mailing list from ACGME and reach out to all of the individual hospitals. Each year that we've done this, we've always been able to add new hospitals to the list. And obviously, the more we can outreach to them, the more information they provide us up front. And I think part of the indication of how well we're doing is how the list is increasing and the number of hospitals participating in the process.
Good. Well, carry on.
I'd like to thank you, Mr. Shumke. I know that this is not the easiest thing, being in different cities every single day that you need to be, but the payout is great. And I want to thank also our Executive Director, Ms. Whitney, for realizing and really re-envisioning what the responsibility of this medical board is and to be much more consumer friendly. And who are our consumers, and they're not only the patients of the state of California, but they're also the doctors and our new licensees. So I want to thank you as well for that. And the direction from, the old adage, no offense, the fish stinks from the head. We're lucky. It's not that it stinks, but, our head is really, it's
But our
only,
fish has a beautiful hat today.
beautiful hat, Miss Whitney. But it really is a difference, a change in the leadership, and I want to applaud the staff from the top on down. And seriously, thank you very much. We have a public comment from Robin Meeham from UC San Diego. Would you like to come forward?
Hello, my name is Robin Meehan, and I am a House Officer Administrative Manager for UC San Diego. And I just wanted to comment on how much we appreciate you guys letting Kevin come to the facility. The service that this provides is insurmountable. When we first found out that he possibly wasn't going to be able to come for one of our licensing fairs, our first question was, we'll pay you. How, what can we do? And so
okay,
I'm going to throw that out to you.
Okay.
Is if it looks as though that is going to come to pass again, if something could be put into place where we had the opportunity to actually pay for his travel and his stay so that we didn't lose that valuable commodity that you offer, that is something that we would certainly look at.
And I want to thank you very much, but the restriction was a state restriction on travel. It had nothing to do with the ability to pay for the travel. So thank you for the offer.
Okay.
You want to move UC San Diego closer to Sacramento? They might appreciate it.
No, thank you. I appreciate the offer, Howard. Very generous. I do appreciate it. With the actual fair itself, we hold two. One is in August, and that's for our PGY2s, and then we hold one in March, and that's for our PGI1s. And the feedback that we get back from our residents is just incredible. They have the opportunity to sit down and talk to Kevin. If they have a problem, it's taken care of right then and there. And the iron mask, I guess, for lack of a better word, is gone. You're not untouchable any longer, and he's put a face to the medical board. And he is approachable, he's honest, he's certainly doesn't hold any punches. If he's got something to say, you know exactly where you stand, and if you have a problem, what you need to do to get it fixed, and you don't walk away scratching your head going, huh, what did he mean with that? So we haven't had anybody not license that should have licensed on time. So thank you very much for the whole process. I'm sure there was more, but I'm a blithering idiot and I'm stammering and can't say anything.
No, we appreciate your comments for sure. I mean, I thank you, and I know that this board is well aware of because we've heard you, but there are other people out there
Yes.
They could be sent further. Written remarks would be appreciated.
Oh, okay, I can do that. I can write. That's no problem. But thanks for letting him come in again. Thanks for the opportunity.
Thank you very much for coming. Do we have any other public comments? Do we have any? Okay, well, let's move on the agenda, please, to item number 17. Ms. Ehrlich, would you come forward, please, and report on midwifery? Or the MAC, actually, you report on MAC. Don't do on midwifery.
Good morning. The licensed midwife annual report summary is in your packets. Page 131, item number 17. This is the report from the 2010 data that was reported by the licensed midwives in California. I would like to point out a couple of things in this report. First of all, if you see the number of clients who were served with the supervision of a physician, the number comes to 6.5%. We are absolutely clear that supervision is essentially unavailable in California. It's kind of remarkable that we even have 6.5%. I'd love to talk to the midwives who report supervision and find out what their arrangements are, because by far most of the state California licensed midwives cannot attain that, primarily because of malpractice insurance requirements, that the physicians not assist anybody who is helping with home birth. The collaboration total comes to 58%, just shy of 58%. So there are significant numbers of midwives who are able to get some level of cooperation and consultation and work with physicians to ensure that we have the best possible care for mothers and babies in California. But it is still a fairly low number because the doctors simply are not allowed to help us. The number of women who were served by midwives who were considered good candidates for home birth at the onset of labor, 2,245. The transfer rate of women having to go to the hospital or of newborns having to go to the hospital after birth is about 20%. And this is consistent with the information that we have from home birth practices in many areas of this country, of Canada, of Holland, of many places where home birth is accepted and supported, that about a 20% transfer rate is a reasonable rate. That means that the midwives are doing their jobs. They're identifying those mothers and babies who are in need of extra care during labor or birth or after, and are getting them to the care that they need. That does also mean, please note, that 80% of mothers and babies are staying at home. And that is a high rate. That is 80% of mothers and babies who are well, who are healthy, and who remain so throughout the process of birth and postpartum. The cesarean rate for these women who began their labors at home, 8.5%. This is at a time that the cesarean rate is 34% and rising. I realize that we can't completely compare them because that 34% includes women who were unhealthy to begin with or who had severe problems that developed during the pregnancy, but it is an extremely low rate given the climate. And that is extremely cost-saving to the healthcare system, that we have this low rate of intervention. I'd also like to point out that there is a huge push within medicine in general to lower hospitalization rates. And they are trying to lower hospitalization rates for women, for people, for citizens, for human beings who are ill to begin with. And I say, well, why don't we try lowering the hospitalization rates for women who are healthy and well? It would save millions of dollars in our current system of trying to lower the healthcare costs. Maternal mortality rate in this reporting year, 0. Perinatal mortality rate, difficult to tell because of our form, which once again is not really adequate. At one place it looks like we had 2 perinatal deaths, and that is an extremely good rate. Another place in the form it looks like we might have perhaps up to 7 perinatal deaths, and that is on page... Excuse me for not having that noted in my notes. I'm not finding it at the moment. It's a place that has reasons.
There's a page 6 that says fetal demise diagnosed, live-born infant who subsequently died.
Page
6, but I don't think that that's...
Page 132 does not have any numbers for outcomes.
The number 132, page 132 does report infant deaths.
Right, but it doesn't have any numbers marked.
And there it is 0.
Right.
That is correct. At that place it is 0. On page 137.
136. 136. Page
Just
136, that's a 7.
That's the 7.
Right.
Yes, that is the possible 7. But then on page 136, where we are asked to list the reasons for the deaths, we only have 2. So this is another area where we have great discrepancies in this report that calls into question what we're getting here. What information do we have? Is this valuable for any of us? And it is another of the reasons in this 4-year list of reasons why I believe that we need to change our reporting system to go along with the Midwives Alliance of North America reporting system, which is epidemiologically created, designed, and overseen by specialists in the field of research and epidemiology. And it is devoted, the MANA Statistics Gathering Project is devoted to seeing that we have the most accurate information that we can possibly have. This reporting instrument is clearly flawed. I have said it before, I just say it again. And I will be asking the Midwifery Advisory Council to talk about this and hopefully move to ask that we shift to the MANA statistics. Another of the things that I have done in this, having received this report, I have put together, and it is in paper and pen because I'm still one of those people. I've put together a summary of the 4 years that we have had this report. Our wonderful Cheryl Thompson is going to put this into a computer for us, so it will be typed clear and readable, much more so than my handwritten summary. Anybody who is interested in seeing this can ask her for it, and it will hopefully be ready for the Midwifery Advisory Council meeting on December 8th. I would like to point out that it is remarkably consistent over these 4 years, despite the flaws. The major preponderance of transfers are for completely non-emergency reasons. We're talking about mothers who are exhausted, dehydrated, they need pain medication, things just aren't going well. There are very few urgencies and emergency transfers. Again, the midwives are doing their jobs well. I would also like to just express once again that the barriers to care that midwives have in the state of California are increasing unnecessary risks for mothers and babies. We have had a case recently in the Bay Area where a midwife brought a mother to a clinic where midwives in that area have been able to get ultrasounds, biophysical profiles, testing at the end of pregnancy to make sure that a mother and baby are well. She brought this woman there at 41 weeks and 3 days. Everything looked good. They scheduled another follow-up at 41 and 5 days, but there was decreased fetal movement, so the mother and the midwife went to the hospital where she was diagnosed with low amniotic fluid and was recommended that she induce immediately. She wanted to talk about that with her husband, so she signed out AMA because they wouldn't let her out without that, so that she could simply have a couple more hours to discuss this with her husband. Meantime, she tried to go back to the clinic where she had had the ultrasound that showed she was well. She wanted to have that reaffirmed, to have a second opinion on what this ultrasound showed. And she was refused by that clinic, and they were told at that point, the midwife was told, that they would no longer accept home birth women to come into this clinic to have this kind of review made to ensure that mothers and babies are okay at the end of pregnancy. They decided to go ahead with the induction. 5 hours after they signed out IMA, they returned to the hospital, and she was induced and had a vaginal birth 26 hours later. The mother was not pleased with how she was treated by the clinic, by the hospital. The midwife was grilled by the doctor who took them into care, and asked why she didn't have supervision, who her backup was, why, knowing that this is required by law, she did not have this help, and was told that she was going to be reported to the medical board because she does not have supervision. 2 weeks after the birth, the woman reported uterine tenderness in her postpartum. The midwife examined her, saw that she had fundal tenderness. She did not have any signs or symptoms of sepsis, but that her fundus was at -4 fingers at 2 weeks postpartum, which is what is called subinvolution. Her uterus was not returning to the proper state in a timely manner. The midwife took her to a private ultrasound tech because nobody would accept her mother. The tech saw a mass in her uterus that he felt was consistent with perhaps retained tissue and a clot and fluid in her uterus. And then the midwife determined that this mother needed medical care. The mother refused to go back to the hospital that she had been seen at for her labor and birth because both of how she and the midwife had been treated. They went to a different hospital, to the emergency room, where they discounted the ultrasound of the tech, said that he is not trained and not adequate, and they didn't need to repeat the ultrasound. The doctor who met them at the hospital did labs, did a bimanual and a speculum exam, told her she was fine, and sent her home with normal postpartum instructions, despite the fact that her fundus was too high, and despite the fact that there had been this ultrasound that had been seen that had shown potential serious issues. We are unable to take care of the mothers and babies in California in the ways that we need to, and supervision remains the single biggest stumbling block that we have. I know that we are going to be talking about rewriting, or not rewriting, trying once again to write regulations for supervision so that it might enable us to have better access to the tools of our trade. I would like the medical board to consider the fact that despite the fact that that might be helpful, I do not think it is going to take care of our problems. We still have midwives in the state of California who are losing lab accounts because we do not have supervision, who are unable or are losing office space because the landlords will not rent to us because we do not have supervision by a physician. The list goes on and on. I really hope that the medical board can work with us for our combined mission of protecting the consumers of the state of California. Thank you.
Thank you, Ms. Ehrlich. Are there any questions? Dr. Carrion?
I have a couple of questions. Can you tell me what is the reason why the doctors, they don't want to work with you?
We actually have significant numbers of doctors in the state, Dr. Carrion, who would like to work with us. It is the malpractice insurance companies who refuse them the ability to have anything to do with home birth backup. They are threatened with loss of their malpractice insurance, sometimes retroactively, if they help us. That is a primary reason, I believe, why a significant number of doctors in the state will not work with us. There are certainly a significant number of obstetricians in the state who simply believe that we should not be working, who simply believe that there should be no home births and that midwives should not be functioning, and that they will not help us for those reasons. I also do recognize that there are some doctors, some obstetricians in the state who might help us if we worked according to standards that they felt were the proper ones. I would like you to consider that the ACOG standards that are held up to as the highest standard are obstetrical medical standards. They are not midwifery standards. And it does not necessarily work at home for us to operate on obstetrical standards. And in fact, if we were to function as obstetricians, we could be prosecuted for practicing medicine without a license. The midwifery standards are different. We are a distinct and separate profession. And we must begin to honor and recognize that these standards are doing a good job. Take a look at these reports that we have. We are doing a good job of taking good care of our mothers and our babies. We are having good outcomes, and that is without supervision. It's without even access to collaboration, and it is with extreme barriers to care.
Karen, I'm going to ask you to shorten your questions up, but thank you for that. Dr. Salmonson?
It just seemed to me that those statistics need to be presented to the malpractice carriers because they base their rates on statistics. And I really feel the barrier, and I believe, and I'm not OBGYN, but I believe the barrier, at least a significant one, would be the malpractice thing. No doctor dares be without it. So it would seem the argument needs to be made to the malpractice carrier to encourage them to, the statistics bear this out.
Thank you very much. Thank you.
Quickly, I know that the reason that you are able to practice is because of legislation.
Yes.
Actually, you were practicing, but where the protection came from was legislation. And I believe was that Senator Figueroa who carried that, or?
Lucy Calais.
Lucy Calais. I'm wondering if you have not talked with perhaps trying to get another legislative sponsor.
We have tried quite a few times to get another legislative sponsor. Senator Figueroa took over our championship after Senator Calais retired. And since Senator Figueroa has been termed out, I personally have tried several times to identify a legislative sponsor, and I know that the California Association of Midwives also has been trying to do that. We continue to try to do that, and as you know, without a sponsor, we can't have legislation. But it is certainly within our strategy to try to get legislation.
Okay.
Thank you. Thank you for your report. I'm going to move on the agenda. It's starting to get pressured. So I apologize, Ms. Ehrlich. I'm not meaning to cut you off, but I need to move the agenda forward. And ask Ms. Threadgill to come forward, please, to give us her enforcement chief's report, please.
Good morning. If I can have you turn to agenda item 18A, may I have a motion to approve 15 orders to restore license following completion of probation and 2 orders for surrender of license during probation or an administrative action.
A motion? Thank you. I have a motion from Dr. Lowe, second from Dr. Dussault. Any public comment? Any comment from the board? All those in favor, please say aye. Aye. Opposed? Okay, thank you. That's so done. Next is the expert reviewer, utilization review.
Agenda item 18.
Reviewers?
No.
Those are penguins.
No, she's doing. The next agenda item is 18B on page 75.
75.
Which reflects the use of 382 experts to review 672 cases during the past quarter. The number of experts in our database continues around 1,200. We continue to seek experts and have a need for experts in the specialties of psychiatry, addiction medicine, and pain management. As mentioned earlier, legislation 541, as Ms. Whitney mentioned, is something that has been passed that we anticipate will make it a little more difficult to improve our timeline in this area of obtaining experts. We anticipate that it's going to add some time to the process because of the manner in which we will have to seek contracts for each expert. Providing an adequate training for our potential experts has been an ongoing challenge. Deputy Chief Laura Sweet has been working on improvements which included providing interactive training to the reviewers. However, we have run into a technical obstacle that may prevent the interactive portion of this training as originally envisioned. And we're still working with UC Davis to try to work this out, and Deputy Chief Sweet will provide a status report regarding whether we've achieved a workaround for this during the next meeting. I would like to acknowledge the enforcement staff present today. I ask Kathleen Nichols, she's the supervising investigator 2 for the southern area of the state. Also, Eric Ryan, who has just been hired as a result of the freeze exemption, the new supervising investigator for San Diego District Office. And also we have an investigator here today, Senior Mary Beth Rodriguez. Thank you. The enforcement program has a current vacancy rate of approximately 25% for supervisors, 19% for investigator positions, and this makes it 21% overall. We received 5 investigator freeze exemptions and immediately conducted interviews, and we're well into the hiring process for those positions. We have candidates in background for all of those freeze exemptions that we've obtained. We also have requested an additional 7 investigator freeze exemptions, and we're advertising and beginning the interview process in preparation for the receipt of those exemptions. Additionally, we have selected a candidate for the Fresno supervising investigator position, and that candidate is in background at this time. We previously received freeze exemptions for medical consultant positions, and we have begun filling those positions as well. The next priority for enforcement will be training for the new hires. Fortunately, the majority of investigator candidates that are in background will not require a basic academy and will only need to have an abbreviated training course from the medical board itself. They won't need to go to the basic. Most of these candidates are SROA candidates that have been identified from Justice.
Excuse me, what is SRO?
State restriction on hiring. Those are candidates that are pending the loss of their job with the state. So we're pleased to be able to hire individuals of that caliber and also to keep them in state service so that they won't lose their job. DCA is currently conducting a pre-audit risk assessment of the complaint unit. This risk assessment is to identify areas where process improvement is necessary, and it is anticipated that it will last approximately 1 month. The individual conducting this assessment is from the DCA Audits Unit, and he has been provided space at MBC headquarters to facilitate his access to procedure manuals, complaint intake process, prioritization, and employee interviews. So this is underway now, and I thought that you should be aware of that. The complaint unit continues to receive an increased number of consumer complaints. At the May quarterly meeting of the board, I reported that the complaint unit was experiencing an unprecedented number of vacancies resulting from retirements and promotions, along with an increased number of consumer complaints. As a result, we re-examined priorities for the expenditure of resources and determined that we were not able to pursue certain complaints. I am pleased to report that we are again able to pursue the majority of these complaints. The vacant analyst positions have been filled, with the exception of one position that is vacant as a result of an October retirement, so it's very recent. Additionally, we have hired an analyst to staff the citation and fine program. I would now like to turn to the statistics on page 143, agenda items 18C2. These statistics that are displayed here are gathered, are based on the calendar year as opposed to the fiscal year. And the data I'd like to point you to is that the average days to conclude investigations not resulting in prosecution continues to decrease. I'd also like you, and although we remain over our statutory goal, there has been some improvement in that area. I'd also like to point out that the average days to obtain a suspension order has decreased in comparison to the previous 2 years. On page 144, the number of citations issued decreased. This was due in large part to the vacant citation analyst position, but with the hiring of Marco Armas, I can see that these numbers will start to pick up in the future. On page 145, there is not, if you will note, there's not been much variance from fiscal year to fiscal year in the average days to complete the complaint unit processes. In the investigative process, we are still confronted with the problem of the time it is taking to acquire the medical records. Although the timeline has not increased during periods of multiple challenges, there remains room for improvement. This is an area that presents an opportunity to work with the subcommittee referenced earlier by Dr. Lowe to identify additional process improvements. Can I get, Kim, could you help me with the slide? I don't know where it is. Okay. In July of 2008, Enforcement made recommendations to the board designed to improve the investigation process timeline. Since that report, we've accomplished the following, and on this chart reflects the goals that were set back in 2008, July of 2008, for each of the milestones. And if you'll note, we're well under our goal. We remained consistent in the complaint unit processing time. And we have been consistently reducing the time it takes to complete the investigation process. Our goal is 275 days, and our last fiscal year, the time was down to 312, and this has been a steady progression. The overall time to complete the entire administrative process is still a problem that we need to address. But I thought I would point out that we did set goals, and we are moving right along to achieve them, and I want to now reference some of the things we've done in order to accomplish this. We've obtained an amendment.
4, 5, 6, 8. We need 9. Oh, we have 8.
The next. This is a chart which reflects what we've done in each area in order to try to improve what we're doing, and then the bottom box reflects overall things that we have done. And I'd like to point out that in order to improve the time it takes to obtain medical records, the medical board hosted and developed training in April 2011 for investigators and deputy attorney generals, underscoring the importance and techniques to obtain records in a timely manner. We've also had meetings with Kaiser North and South regarding improving efficiencies. We implemented exchange of electronic records with Kaiser North, and we intend to expand this to Kaiser South. On January 1st of 2010, BMP Code Section 2225.5 was amended to require the production of certified medical records. We entered into an agreement with the Office of the Attorney General to assist with the preparation of subpoenas, and we revised our subpoena policy to greatly reduce our preparation timeline.
So I want you to continue with your report, but I also want it noted that we are going to listen to your report in the continuation form as a subcommittee since we've lost quorum. We're not voting on anything, so we don't need a quorum, but on the other hand, I just want members of the audience to be aware that I am aware that we've lost quorum, and
okay,
I'm just making that point. Thank you. Please continue.
In the area of completing the physician interview timely, effective January 1, 2012, AB 1127 provides incentive for physicians to attend and participate in physician conferences. And this should go a long way to help us schedule more timely interviews with physicians when we request it. We also modified policies to expedite the method of contact with physicians. Towards recruitment and retention, during fiscal year 10-11, we began continuous testing for investigators. We work with the department in order to implement this. We also established a new investigator class, which will facilitate retention because the investigators will not have to go through the exam process for senior any longer. We're continuously seeking exemptions for hiring investigators, and we have online continuous testing for medical consultants. Overall, investigators were provided time management training. We implemented the Age Case Council in 2009. Manuals and templates have been placed online for easier access. We sought and received legislation SB 541 exempting us from the contracting process for the hiring of expert reviewers. However, that is certainly going to save us the time it would have taken had we not been exempted from the process, but we'll still have to be mindful that it may add a little extra time to our timeline. We also worked with the Attorney General's office to revise the vertical enforcement manual and guidelines to streamline our processes and procedures. We are currently revising the expert reviewer training program. We developed comprehensive statistical reporting for critical data markers, and that's reflected in your packet under agenda item 18. We revised the model disciplinary guidelines, and they will be going to the Secretary of State hopefully mid-January. We've been meeting with OAH to facilitate efficiencies in the administrative process.
Why is the expert reviewer issue going to cause you to have more time?
The contract process, prior to the revision of the contract process, we only needed to have a vendor data record form on file and an agreement with the expert, and we were able to pull and use them. Now we're going to have to complete a contract each time we use the expert. So it's anticipated that this may add a little more time. We never had to previously redo it once we had it on file until we renewed the agreement with the expert.
So they are reviewing cases. The contract is causing you to wait to review cases?
No, it's just securing the expert for the service that we want him to render.
Okay.
May I explain?
Okay, because I don't understand.
The department put out a memo last year saying that the process that was being utilized in the past did not comply with the law.
Right,
and the medical board and the contractors board took the lead in changing the law. But there still is a contract required. However, there's no pre-review of that contract.
It's automatic.
It's my understanding that once there's been training on the process, that yes, the contracts are delegated to the individual boards, and they get to enter into the
contract before that expert can review the case. So it may add a small amount of time, but it will still change what we're currently doing.
The object was not to be more time engaged, it was to lessen. So if this is going to be an issue...
No, what I'm saying on this is that without 541, we would have had a much lengthier process. However, 541 did not eliminate all the time that we may have to expend. And I'm going to be watching that because I anticipate that it is going to add some time for us in the way we have to get the contract each time with the expert before we can utilize his services.
And we can't have them sign in advance and be vetted in advance and then just use it in the time that you need it? I mean, I'm just trying to figure out that the system was supposed to work, and this is sounding like you've got an immediate barrier, and I'm concerned.
Well, I don't know. We're going to try to work around and see how well we can work with it. We haven't implemented yet, but I'm anticipating that there will be a slight increase in time.
20 minutes is enough.
Okay.
Madam President, if I could, just so we all understand each other, it's my understanding that the department has pre-allocated a set of contract numbers to the board for rapid execution of these contracts.
Good.
And just so that we're all square, the abbreviated form contract, I would say short form contract, but our Business Services Office kindly reminds me that there's a short form contract already, consists of 2 pages with the exception of about approximately, I think, Anita, if I'm not correctly, 7 blanks to fill in, including the signature.
I just want my object of the question of this is to make sure that we're not going to have red flags put in our face to start with. The object was that this was supposed to make things go smoother, and we were just supposed to abide by the law. And I'm just concerned that I don't want to hear that there's going to be barriers to getting the job done in a timely fashion. That's all. You watch it. I'll watch you.
I'll keep you informed.
Okay. Thank you.
That concludes my report.
Thank you. Any questions from the board members? Any public comment on the report? So the question is now for the board is that it's 12 o'clock. We still have to get through the vertical enforcement report, Mr. Ramirez. We also have to get through the ledge report by Ms. Simoes and the
report from the executive committee and what we thought we would have.
Oh, so it's okay to take the break now?
I think so.
Okay, so we won't ask the board. We're going to take a break now. It's 12 o'clock. We're going to reconvene at 1 o'clock. Lunch is available for $10 where the breakfast was in the restaurant. It's there for the public. It's there for the members. It's there for anyone who's hungry, and we're going to put you on hold until 1 o'clock, Carlos. Okay, I apologize.
No problem.
Okay, thank you for your patience. I'd like to call the meeting to order, but before we get started with the agenda as is, I'd like to ask Ms. Threadgill to come back to answer just one question, and it's a point of information so that we can have it recorded in the minutes specifically for that reason.
That's okay. I can go.
Ms. Threadgill, would you answer the question as to the location that a doctor can go to for remediation is picked by the Medical Board of California, or it's up to the doctor to determine where they'd like to be? Whatever, when a doctor signs a stipulation for terms and conditions, they can go to...
If the term and condition that you're speaking of is the assessment and clinical training, has to be a program that's approved by the board. And we've already approved the PACE program as a qualifying program, and we would accept any equivalent program.
So I just want to make sure that in the minutes it reflects that we do not mandate where they go. They just have to be an equivalent program to something that we have approved, correct?
That's correct.
Thank you for that clarification. So now moving on the agenda without glasses. Without I've got it in my pocket, sorry. Can't see. We're going to move to the Vertical Enforcement Program report. Mr. Ramirez?
Thank you, Carlos Ramirez, Office of the Attorney General. As you know, I'm in charge of the Health Quality Enforcement section, and as many of you know, all of you know, is the Health Quality Enforcement section does medical board for the medical board. It is a dedicated section to perform the functions, the legal work for the medical board. The section started in 1991, and in 2006, the Vertical Enforcement Program was initiated. Turning to, and with me is Gloria Castro. Gloria Castro is one of the newer supervising deputy attorney generals, and she's from the Los Angeles office.
Welcome.
Now, directing your attention to slide number 1, this is a description of the functions that our office performs with the medical board. and with medical board investigators. As you can see from the list, which is a partial list, it is a highly interactive system of service delivery. It requires both investigators and deputies to work together on some of the most important aspects in the investigation process. I would be glad to answer any questions that you would have with regards to any of these functions. And if you can, of course, you have questions now, I'll be glad to answer them. If you want to hold on to those questions until the end, that's fine.
Sure. Looks like we'll hold on to them until the end.
And now directing your attention to slide number 2, these are some of the fiscal challenges that we have faced in the full implementation of vertical enforcement. Most of these, in fact, not all of these, are factors that you have heard over the past 2 years, and they have impacted the timelines in different degrees of length. And again, these are same things that you have heard over and over again. You're familiar with them. And again, if you have questions with regards to any of them, I would be more than glad to answer them.
Madam Chair, if I could ask you a question. I know we have a new Attorney General, and I guess my question would be, is this Attorney General supportive of the vertical enforcement program and obviously trying to provide sufficient resources so that it can be effective?
Yes, yes, she is. She's very familiar with the work that we do. She's very interested in the work that we do. And I've had the opportunity to meet with her at least on 2 occasions. One was rather lengthier than the other one, but she's very interested in the work that we do. And the work that we do is highly publicized throughout the office because we put out every important case that the section handles is publicized throughout the office by all of us. We put daily reports out, so deputies and supervising deputy attorney generals and the AG herself gets to view the work of the section, and oftentimes we receive calls from them. And so in short answer, yes, she's very interested. She knows about the work, and just very supportive.
Great, thank you.
Dr. Levine?
Just a question about the second bullet, executive orders prohibiting contracting with experts to evaluate cases or court reporter services. What does that mean?
This occurred maybe about a year and a half ago, and it lasted for approximately 2 months. And there was an executive order that prohibited agencies from.
But it's over now?
Yes, it's over.
Oh.
It only lasted for 2 months, but it does impact the work because it has the effect of delaying the processing of cases. Okay, for example, if you don't have court reporters at OH, you can conduct hearings.
Right, but this was 18 months ago and it lasted for 2 months?
Yeah, exactly.
Okay.
So it ended sooner than it was expected, is that what I'm hearing?
I'm sorry?
It ended sooner than it was expected,
Yes.
Is that what I'm hearing?
Yes.
Okay, thank you.
So it's not a current fiscal challenge?
No, it isn't. Yeah.
Thank you.
Any other questions on this slide? Okay.
And then these are some of the impacts of the fiscal challenges. Okay, and again, all of these are factors that you have heard from in the past, and as far as I know, there's nothing new to them. And again, if you have any questions about any of them, I would be more than glad to answer them.
So let me ask you a question with this specifically. The impact of fiscal challenges as it affects your office.
Yeah, exactly.
And how does it affect your office to affect our office? Is that meaning that investigations are slowed, reports are slower coming forward, that maybe some pressure from your boss to the governor's office with hiring changes and challenges might be appropriate? Can we?
Well, I mean, our office is, I'm ready to do whatever is necessary to assist the board's enforcement program in any respect. But these fiscal challenges or the impact should no way be taken as a reflection on the efforts of your chief of enforcement, because she has worked very hard to overcome all of these factors, but nonetheless they do exist, and they are factors that delay the process of the case.
So we're getting by without. We're doing okay.
Yeah.
Our staff is great.
That's correct.
Smile, Renee. It's okay. That's a compliment.
That was hysterical laughter.
Yeah, right. So I'm not hearing that our bill has been lowered either, right?
Mm-hmm.
We're not, because of your fiscal problems and situation, you're not lowering your bill with the medical board. Is that correct? We're still paying our fair share of the budget in your department?
We're not what?
We're not having a reduction in our bill. We haven't asked for a reduction in service.
No.
I just thought I'd mention that. We're still paying our bill. Everyone's kind of like, it's after lunch. You're all going to sleep. What's the story here?
Good afternoon. I'm going to present the statistics that we put together for you, and they start on page 4 of your handouts. But before we start, actually, I just wanted to definitely touch upon the statistics and how it is that they're compiled. We initially compiled them as a result of a response to a medical board audit, and we've continued to use some of that format up until now, and continue to have a plan to continue to be able to report things that are comparable with what we previously reported to you. We recognize that there may be differences between what you see here presented by the Attorney General and what you see presented by the medical board, specifically Ms. Threadgill's presentation. And we do look forward to continuing to work toward the consensus between each of our departments to decide on proper benchmarks on how stats are reported to you and the public. So in today's statistics, we will show you 4 statistical measures of vertical enforcement. You will see what we reported to you last year. And you will also see an overall figure for work completed in 2010, and it's a thumbnail of all the work completed in that particular year. Now, really quickly on what the defining terms are for each of these benchmarks that are used by the Attorney General's office. Though not shown here on page 4, you will see that we measure cases by received at district office. And what that means is it's the actual date, the earliest date, the first date that a CCU complaint is stamped received at a district office. And as you may know from our vertical enforcement model, the Attorney General becomes involved in an investigation only when it's assigned to an investigator. And it's only assigned to an investigator when it gets to a district office, and the supervising investigator does the assignment. Nonetheless, even though our involvement doesn't start until we approve an initial plan of investigation, we start measuring from the first and earliest received at district office date. And for multiple investigations that result in one file pleading, and we all know that we have physicians that have more than one patient sometimes, each resulting in one counted investigation at the district office, for our statistics we count from the earliest investigation that is filed in that accusation. So we use the oldest date. The second docket event that we think is important for you to know the definition of is the definition of accepted for prosecution. And what that means is that is the date that we at the Attorney General's office sign off on a report of investigation. And what that is here's the package, here's the completed investigation that the deputy and the investigator worked on together. We sign off on it. And that's the same date that we used for accepted for prosecution. And what that communicates to everyone is that the Attorney General is now ready to plead the case. It's ready for prosecution. It's accepted for prosecution in our office. And this date is a little different than what you may be used to seeing. There are two different things that I've seen that reflects what the medical board uses, and one is the date that they transmit the case to the Attorney General's office. That's different than the date we accept it. We have about 5 days pursuant to the vertical enforcement manual to review documents when they come in. And I believe Ms. Threadgill also made reference to it in her statistics by calling it the case referred to AG. Okay, so those are not the same dates, but they're pretty close in most instances. The next docket event that you see up there is pleading sent. And what that is the date that the Attorney General has completed their final draft of a proposed pleading, an accusation for petition to revoke probation, and forwards it to the medical board. And this date, the date pleading sent to client, is real-time filing. We traditionally have been emailing pleadings to the client as quickly as possible. We believe public protection is important, and it's important to get it up on the website as quickly as possible. And so this is a real-time date. And finally, decision signed. And that's the date that you as the board sign a decision in order. It is not the date that your discipline becomes effective. And we use that as the end note to the cases. And you know, it makes no difference what type of decision it is, whether it's by stipulation, hearing, or a default. A decision's a decision for us. And that's when we get out, we're done, unless there's a writ, and then we come back and represent you again. How do we collect this data? There are various ways, and as we move forward, we're getting much and much better at documenting and making sure that all of our processes are audited and represent to you the most faithful representation of what we have, and that it's neutral, and that it represents to you the good and the bad equally. And so we use a system at the Attorney General's office. It's called ProLaw. The data is entered by the users, meaning the actual primary DAG, Deputy Attorney General, assigned to handle the case according to set policies. And we have used our case management system. Folks, they run reports off of ProLaw. And though the data continues to be completed as time goes forward and cases get closed. So one aspect of our data is that it can continue to change just a little bit as things are added and closed out and completed and new things come in. We audit this information, and we exclude and include certain types of cases depending on the calculation, and every effort is made to be thorough. Finally, we do use average days for all of these. Even though we do calculate mode and mean, we don't report those items because the medical board does report, they're reporting in average days, and so do we. The one difference that you will see is that we begin our statistical compilation from January 1, 2006, which is when the VE legislation came into effect, whereas the medical board does do things by the fiscal year. And so that's one of the items that I think we need to, reach a consensus about, so you can get the fullest picture and most accurate representation of what's going on. All right, so as I turn on to the data, what you're going to see are three specific things in our work. Number one, you will see in 2010 the pleadings that were sent to the client, meaning the medical board, for filing. You will also see in 2010 the decisions that were signed by you and that constitute a completed case. So we will show you the average amount of administrative days that matter took. Then you will also see some data that puts together the two parts of the case, the investigative days plus the administrative days. So you can get a full picture of exactly how long the whole process took. And as we move forward, we're completing more and more cases. As of the last calculation of this data, we've completed at least 530 cases that started as investigations received at a district office to decision signed. And finally, we believe it's important to also present to you today the seriousness of the discipline. What did we get? What was the achievement? And so moving on to slide number 4. This answers the question, how long did it take the Attorney General to file, to send a pleading to the client for filing after receiving a completed investigation? And the data represented here from 2005 to 2009, that comprises data that was earlier reported, that was compiled by calendar year. And in 2010, what you see here is actually the thumbnail of the entirety of cases received, received and sent for pleading in that particular year, 2010. And as you can see from the final slide, it took an average of 42 days to send a pleading to the client, which continues to show a downward slide in the average days. Now, remember, these are calendar days, so these are not working days. So really, what this 42 translates to, in view of furloughs, which we're affected by in our office as well, is 20 working days. So our deputies, as soon as they receive the case, are able to file a pleading and get the public on notice as to the physician who's in trouble.
And the good news is they all passed through the legislature and were signed by the governor this year. So I'd like to go first through the sponsored bills. So AB 1127, Brownlee, is the bill that makes it a violation of unprofessional conduct for a physician who is a subject of an investigation to fail, absent good cause, to attend and participate in a physician interview. And that's the bill that Ms. Threadgill referred to earlier in her report. For implementation, board staff proposes to include an article in the newsletter to notify trained board staff, to notify the Attorney General's office, and to update the cite and fine regulations to include this requirement. Does anyone have any questions? Okay, the next sponsor bill is AB 1267 Halderman, and this is a bill that authorizes the board to automatically place a physician's license on inactive status when a physician is incarcerated after the conviction of a misdemeanor, and that would be for the period of incarceration. For implementation, board staff proposes to include an article in the newsletter to notify trained board staff and the Attorney General's office. And then this one actually requires us to adopt regulations. And so the regulations would need to specify the type of notice that needs to be submitted to us to notify us that the physician is no longer incarcerated, and also to specify what would be posted on our website to disclose that that physician is on inactive status because they were incarcerated.
Might I also recommend that the Bureau of the Board of Corrections, or whatever the official title is for our prisons and our jails and our court system, also be notified of this, so that they will know that when they see someone that's incarcerated, they shouldn't be working in the neighborhood clinic.
Okay, yes, I can definitely do that. Okay. The last bill, which has been kind of discussed a lot today, is SB 541. So I don't think I need to go over what that one does again, but that's the bill that exempts us from the contracting provisions for our experts. And so for implementation, we propose to include an article in the newsletter to notify trained board staff, to train our expert consultants on the new process, and to work closely with BCA on the new simplified contracting process for utilizing expert consultants. We'll also need to develop some sort of tracking system that will ensure that no expert exceeds the contract levels and that builds in enough time for whatever extra time this is going to take. And it may not be long, as was stated earlier.
Would this also be an opportunity to do outreach to the specialty boards and to the medical associations to notify them about this, but at the same time, the opportunity for people to participate as expert reviewers and the need to sign up? Would this be not an outreach opportunity?
We really wouldn't use this particular bill as an outreach opportunity. It's just a contract bill, but we do try and use our newsletter, and one of our strategic plan items is to outreach to experts.
Okay. In the interest of time, the next bill I'd like to go to, because I think it's important to go through the requirements one more time, is SB 100. So if you can turn in your tabs in your ledge packet to SB 100. And I set up the analysis a little differently this time. The way I set it up is the requirements for the board, the requirements for the accreditation agencies, and the requirements for the outpatient settings, just to kind of make it clear what this is changing in regards to existing law. So in my presentation, I was just going to go over the requirements for the board and our implementation plan, but if anyone has any other questions on this bill, I'd be happy to answer them. Does that work? Or
I think that works. I think, though, that members, I would request that you at least take this packet and review SB 100, because I would, at a future date, either assign this to either licensing or the education or something, that this needs to be reviewed so we have a better understanding, a fuller understanding of this implication law.
Okay.
The implications of this law. And I'm seeing some shaking hands down there, so it's not just me.
Mm-hmm. Okay, so let's go through the requirements for the board. So the first requirement is it requires the board to obtain and maintain a listing of information on outpatient settings on our website, and that listing must include the name and address of the owners and the facility, the name and address of name and number of the accreditation agency, and the effective dates of accreditation. And the board is required to update its website if the outpatient setting accreditation is revoked, suspended, placed on probation, or if a reprimand is received. And this is basically, the purpose of this is to give more information to the public, to provide one central location where the public can get information on the outpatient setting. Okay, the next requirement requires us, the board, to adopt regulations on or before January 1st, 2013, regarding the appropriate level of physician availability needed within clinics or other settings for use of prescriptive lasers or intense pulse light devices for elective cosmetic procedures. The next requirement is it requires the board to adopt standards it deems necessary for outpatient settings that offer in vitro fertilization. The bill also allows the board, and this isn't a requirement, but it allows the board to adopt regulations to specify procedures that should be performed in an accredited setting for facilities or clinics that are outside the definition of an outpatient setting. And this was to address the concern that some procedures are being performed in facilities, but the facilities aren't required to be accredited by existing law. The next requirement is it requires the board to evaluate the accreditation agencies every 3 years, to evaluate the responses to complaints against an agency, and evaluate complaints against the accreditation of outpatient settings. It also requires the inspection results of the outpatient settings that are, the inspections would be done by the accreditation agencies. Those inspection results must be kept on file with the board and the accreditation agency, along with any plans of corrections and comments. The bill also specifies that the final reports are public documents, and it requires the final report to include the list of deficiencies, the plans of correction or requirements for improvement, and notes when corrective action is completed. And this really allows the board to ensure that the outpatient settings are being inspected timely and ensuring that the final reports are made available to the public. This bill also allows the board to take any appropriate actions it deems necessary if an outpatient settings accreditation is suspended, revoked, or denied. And lastly, it requires the board to investigate all complaints concerning a violation of this chapter. And it also requires the board, upon discovery that an outpatient setting is in operation but not accredited, to work with the district attorney to bring an action to enjoin that outpatient settings operation. And so there's also listed as the requirements for the accreditation agencies and the outpatient settings. And I can go over those if anyone has questions, or I can just go over our implementation plan for our requirements. Anyone have questions about the other requirements? Okay.
Just go to implementation.
So for our implementation, along with the usual newsletter article and notified train board staff, we will also notify accreditation agencies and outpatient settings of the new requirements in this bill. And just as an update, we have an internal meeting in the beginning of November with the staff, but we also plan on having a meeting with all the accreditation agencies in mid to late November to go over with them the new requirements and to work on our implementation plan. We need to establish a process for the reporting of the changes of the data. So when accreditation agencies report that information to us, we need to come up with a process to get that updated on our website. We need to set up a database that can be updated for that listing. And we will be meeting with various stakeholders on standards and regulations for settings that offer in vitro fertilization, because we're required to do those standards in the bill. And then as far as the regulations for the the supervision for laser procedures. Staff is proposing that we reconvene the advisory committee on physician responsibility to specifically address the regulations for the appropriate level of physician availability. We also propose that we need to examine the need for guidance to physicians or enhance regulations related to procedures that need to be formed in an accredited setting. That's the part that allows us to do regulations if we think that they're necessary. We propose to establish a process to evaluate complaints against accreditation agencies and provide feedback or take other action. And then lastly, we need to establish a process to maintain inspection reports, check that they are completed, and issues addressed. And we also need to work with internally work to link the final reports for the outpatient settings on our website. Anyone have questions?
Is there any idea to also notify the district attorneys throughout the state that this is what we're doing, or that they should know what they're doing? Or
yeah, I mean, we can do that. Right now, we work obviously with the district attorneys on unlicensed kind of cases, and if we got a complaint for this right now, we would probably do a preliminary investigation and then work with the district attorneys, but we can definitely notify them.
My concern is that they're not aware of the authority that they have in that way. Okay. And since it's specifically listed in the bill.
Okay, definitely we will do that.
Dr. Salmonson?
Well, I know it's a mundane comparison to the restaurant ABC thing, but I just wish somehow the public would know to look for the accreditation of any place where they're going to have a procedure.
We had asked that when the bill was being designed, and we're told that we need to wait for the next phase, as I remember.
This is basically the beginning phase.
They need to start to look at the weaknesses.
Website, how quick that list can come up, because that, again, is...
There needs to be
in
the office
happens, not wait till disaster occurs.
There has to be something in the office when they walk in. It's not going to happen in this phase. It should be held for the next one.
But in the short run, to have the patient ask, are you accredited? When they book a procedure, where are you going to do it? Are they accredited? And then they can check it out the website, just like they check out, hopefully the physician, they would check out the facility.
And maybe this bill is something that warrants its own, article in the newsletter about these are the new requirements. These are the requirements that outpatient settings be accredited. Once we get our website up with the listing, that you can go to the board's website and find out about your outpatient setting.
In the situation where a doctor would be recommending a patient to be having a procedure in a center, would it be appropriate to then, as part of that newsletter article as well, suggest that doctors, when they're counseling patients on where they're going to go, that they should in fact counsel their patients on asking the kinds of questions that Dr. Salmonson has just raised?
Well, the doctor who's going to have to inform the patient is already probably using an accredited facility.
Well, that's okay.
The patient is the one who needs to know to ask the doctor, is that facility accredited?
Yeah. Right, but I'm trying to figure out a methodology for that to happen. So what I'm thinking of is when a patient is seeing their own doctor and is querying their doctor, and the doctor is suggesting you have to have procedure X.
Yeah, well,
you need to go X to that place. You patient, my patient, you need to check with that surgery center and find out if in fact they are accredited.
The doctor wouldn't. The doctor wouldn't book it unless the doctor.
Oh, so the patient is seeing the doctor that's going to do it. I'm sorry, I didn't understand.
So it's the patient who,
before she sees the doctor, basically, or before he or she sees the doctor. Okay.
I'm sorry. I was thinking that the patient was going from their primary care doctor to a surgery center doctor.
Well, it wouldn't hurt to check, but the doctor would inform the patient to inquire. Probably would have made the inquiry, because they wouldn't be operating an unsafe facility.
That probably would take a lot of consumer education.
That was the issue. I was trying to short circuit, and I obviously didn't do that.
Well, then maybe we can also work with other state agencies to get that information. Links to our website. Once we get the list up and running or something.
Okay, Dr. Levine.
Yeah, I would suggest another implementation bullet, which is to estimate the budgetary impact of this new work that's coming to the board, and then track over time what the actual cost is.
Okay.
Or expense.
Okay.
This is a whole lot of new work.
Yeah. Okay, good. Okay, I'm going to ask that you wrap this up, only because not that I don't want to hear about legislation, I love hearing about it, but I just know that we're going to start to lose members and...
It was already in the plan, yeah, so...
I just want to I'm articulating it for those that are sitting out there that don't know the plan.
Okay, so what I would like to do is, unless anyone has questions on any of the other implementation plans for the bills, I would like to go to the 2012 proposals because I do need board approval to go forward with some of those proposals. Does anyone have any other questions? Okay, so if you turn to your legislative proposals 2012 tab, we have one previously approved proposal, and that's the UCLA Dr. Dowling's International Medical Graduate Program pilot. We are working with UC Office of the President, and they have decided to co-sponsor that bill with us. I just got an email while we were here, and we will be meeting with them and then looking for an author for that bill. Now let's move on to the new proposals. The first one has to do with non-practice license status and the board's authority to impose discipline. So the medical board recently lost a court of appeal case related to taking disciplinary action against a licensee that held a retired license. The respondent's attorney alleged the board lacked jurisdiction to impose discipline because as the holder of a retired license status, the respondent was not permitted to engage in the practice of medicine. Board staff and legal counsel believe the board does have jurisdiction to impose discipline on any license it issues because the licensee can opt to change their license status by meeting limited requirements. If the board lacks jurisdiction to impose discipline, it may create a retired status loophole that would insulate any licensee from discipline by transferring his or her license to a retired or inactive status. However, unfortunately, the court ruled that the holder of a retired status license is not a licensee under the board's jurisdiction and that the board's disciplinary authority is relevant to the holder of a retired license only if and when the retired licensee seeks to return to the practice of medicine and files an application with the board. Board staff would like to sponsor legislation to make it clear in statute that the board retains jurisdiction over all licensees regardless of the status of his or her license. And this also affects the bill that just passed that puts the misdemeanor incarcerations in an active status. So it's actually a really important one. So what I need is a motion to approve the board sponsoring this.
Second. Any public discussion? Any discussion? All those in favor, say aye. Aye. Any opposed? Please go ahead.
Okay, thank you. Okay, the next one is it could be an omnibus bill candidate, but basically it has to do with the ability to send renewal notices via email. As everyone knows, we'll be moving to a new system, Breeze, that will allow physicians and surgeons to receive notifications via email. In statute, Section 2424A, it impedes us from, it actually requires us to send a hard copy via certified mail. And so in order to save mailing costs, mailing time, printing costs, etc., the board would like to amend statute to allow notifications to be sent via email only if the physician opts for that. And it's clear it would make it clear that it would only be if they choose to do it that way. But the way existing law is written right now, it impedes, even if they chose to receive it that way, we would still have to send it via mail. And so this, like I said, it could be an omnibus bill candidate if it's pretty non-controversial, I would think. But we would like approval to move forward with either omnibus or standalone legislation for this.
So a motion?
So moved.
Second? Second. Any discussion from board members? Any public discussion? All those in favor? Say aye. Aye. Any opposed? So done. Okay.
Okay, and then we have, last year we never got language into an omnibus bill. I have from Senate BNP, they promised me it's going to go in December. They have it. It's all ready to go. So everything that I've talked about previously would go into the bill for this year. It somehow didn't get in this last year. And we do have one more new change for an omnibus bill provision, and it's adding a new provision that will establish a retired license status for licensed midwives, similar to the retired status for physicians. It appears to have been left out due to an oversight when the licensed midwife statutes were being put in, and so most practitioners, there's a status that allows for retirement status where fees are not required, and I would think this would be an omnibus bill candidate.
Okay, motion?
So moved.
Second? Okay. Any comments from the board members? Any public comment? All those in favor? Aye. Aye. Any opposed? done, thank you.
And my one last little thing is other legislation that we're aware of. As you heard the last meeting, we know that the CMA will likely be coming up with a proposal related to physician health program. We will be meeting with Department of Consumer Affairs and other, I haven't seen language yet, but just a reminder that that's still on the horizon. We heard from Mr. Cooney earlier on a potential bill related to integrated treatment of cancer, so that's something that we'll be watching for. Lastly, the board is also aware of potential legislation related to cardiovascular technologists or registered cardiovascular invasive specialists. That's how they're certified. This is basically a new licensure type, similar, I don't know if you remember a bill that became a 2-year bill that had to do with radiological technology. So this would be a similar kind of thing. I'm not sure if they will be proposing it to be put in the medical board or not. I think that might be something they're still working out. But the potential legislation will propose to create a new licensure category for the CTs, cardiovascular technologists, or the RCISs. Right now they're certified. There might be someone here, and I'm not sure, from the Society of Cardiovascular Professionals to provide public comment, but I'm not sure about that.
I don't have a slide.
Okay. And that's all that I have unless anyone has questions.
Any questions? Thank you very much. Busy lady. Moving on the agenda, Mr. Shunke, please, status regulatory action.
Good afternoon. I will limit myself to 2 minutes. If you will look on your agenda, please, to page 150, which is the matrix of your pending legislation. I would like to provide you with an update on only two items, please. In the fourth row, the disciplinary guidelines. In the second column, would like to indicate now that this has left the Department of Consumer Affairs, and this should now indicate that that's where the review is. Pursuant to law, the Director of Consumer Affairs has granted an extension of the deadline for this file to be submitted to the Office of Administrative Law by December 14th, and therefore in the third to the last column, to DCA and other control agencies, it should reflect that it went to the Consumer Affairs, to agency on October 12th. Below that, the sponsored free healthcare event would like to show that it was sent to, hand-delivered to the Department of Consumer Affairs on Tuesday of this week. This would implement a bill that took effect January 1st of this year, and I'm happy to report that the Medical Board of California still is the first board that has moved forward with a reg packet to implement this, and assuming that it moves through the review process with the department, with agency, and finance, that hopefully by the beginning of the next calendar year, or at least the next board meeting, we'll be able to report to you that it either has been approved or is darn close to being approved, and to ensure that you don't run out of things to do and that staff continues to stay busy. Based on Jennifer's report of new legislation, we are starting to meet and discuss regulations that will need to be set for hearing during the next year, and there will be plenty of those.
Thank you very much. The medical board, you should know, was called out on the call that was hosted by DCA this month as the premier entity that has moved forward with the regulations and the rules for professional staffing free clinics statewide. So I forgot to mention that. So we'll move on the agenda to number 21. And I know that we're going to lose members, but I would hope that we would continue to take the advisement of the materials that will be presented and all the hard work that has gone into this strategic plan, the draft strategic plan, and I know that it'll be what it'll be. It's fine. So I'm going to turn the meeting over to Ms. Kirchmeier and Ms. Cordray, and you move forward.
Could I ask a question?
Yes, please.
If we're going to lose members so that we won't be in a quorum, could we address the question of next year's schedule if it requires a vote?
Okay.
So that we're still in a quorum?
Yes.
What agenda item is that? Does it? I don't know if it does.
Yes, it does. Right here. It's number 23. Okay. So number 23, just sit at the table for a minute, please. Number 23, we have the approved board meeting dates for 2012. There's been a request to move the July 26th meeting to a week earlier. due to one of our members who goes on a medical mission every year, and that has already been scheduled. In order for her to participate, I'm going to ask that this board approve the date 1 week earlier of the board meeting. Is that correct?
That stated better than I
need
could
to
have
make her
stated
the
it.
motion,
I move that we advance the date 1 week forward.
and I need a second to the motion.
I'd love to second that one.
Is there any comments from the board members? Is there any public comment? Seeing or here?
I need to let you
Well,
know.
I would just,
consequences.
could I make?
Oh,
a comment first?
consequences, wait, so
Yeah,
over here.
No, I just what that would mean in terms of dates, and then Ms. Whitney will address that. Just so we counted, I counted out the dates on
Wait, so let her make her comments.
So the interval,
Wait,
no, just so we know the numbers, the interval of the dates, okay, maybe it's irrelevant, you're right.
Right. Wait. Thank you, Ms. Whitney, go ahead.
Okay. The consequences of moving it ahead means that we may not have enough time to put together regulatory files that you approve in May to be heard in July. And as long as you're willing to accept that consequence, then those regulations would be heard at the November or October meeting and not heard at the July meeting.
Fine.
So what are the proposed dates, the 19th and 20th?
19th and 20th versus 26th and 27th.
So it would be 84 days is the current interval between May and July. With the proposed change, it would go down to 77 days versus 84.
It's not a big deal. Okay.
Thank you.
Okay, no public comment, no comment from the board members. All those in favor of the proposed change, please say aye. Aye. Any opposed? So it's done. Thank you very much. Okay, so any other quorum, but let me just ask now, are there any other pieces of information that we need to know now that would need a vote in case we lose a quorum in the next 5
minutes.
5 minutes? No? Okay, so continue. So we'll go forward. So we don't need a vote on the strategic plan changes. We do not need a vote, correct?
Do need a vote, yes.
So let us have, let me ask this question. Let me have a motion that suggests that we will accept the changes, the objectives, the critiques, the language in the spirit of the go-forward basis without any major discrepancies. Could I have a motion that we would accept it as presented from the executive committee? Is that what you want? Is that appropriate?
I had actually kind of flipped it around just a little bit.
So flip it around so in the next 5 minutes we can vote.
I will. I'll do this very quickly. What you have in front of you is a handout of the objectives that yesterday the executive committee actually went through the entire plan. The ones that you have marked there very manually is actually the ones that the executive committee approved without any edits yesterday. On that also is a page number that ties it to your executive committee document file in front of you.
Entertain a motion to accept these as a consent item.
Yes, I will.
Thank you. That's what I was trying to do. So I would ask for a motion to accept this as a consent.
So moved.
Okay, and a second? Do I have any public comment? Do I have any board comment? So all those in favor, please say aye.
Aye.
Okay, any opposed? So we're going to go forward now with a deep breath and not worry about 2:30, okay?
No.
Okay.
No,
Then we
yes,
will also
wait.
be moving through, those that we did have edits on, I'm going. 3.5, we're actually, there was an issue with the contacting database, media database building one. We're going to build relationships with major media. And we took out meet with all major newspaper editorial boards because that was actually duplicative to another one. Rather than educate physicians regarding the newsletter, we're going to inform physicians. That was a request that was made. And then we also added in a bullet for encouraging professional associations and societies to include a link to the board's newsletter. In 3.10, we just added in including community newspapers. That was a request by one of the executive members. Rather than tighten, we put strengthen, and we added in for the board members, prepare members to be effective when communicating with legislators and their staff. We just changed white paper to be an issue or position paper. That was just a minor edit. 5.1. And this was changing for the enforcement timelines. We changed it to reduce discipline, complaint processing, and investigation timelines by 10 to 20%, and then reduce complaint processing average to under 70 days. So some minor cleanup. And then we changed it to look at the delays in the board's processes from complaint handling through disposition, and then identifying best practices rather than comparing. On 5.5, we just made it easier, establish and conduct an annual self-evaluation. 5.8, we just changed a typo, just minor modification of a misplaced modifier. In 6.1, this was probably our largest one to change. 6.1, we put invite appropriate speakers to address the board about the new healthcare law and how it will impact. We completely deleted 6.2 because it really didn't fit in that one. It was more with access to care. So we will be looking at the scope of the access to care and possibly putting in another one for public health. And then we just added in 6.3, expand the scope of the access to care and educate consumers and licensees on public health issues. So I would entertain a motion to accept all of those edits as stated.
Dr. Salmonson?
I'd like to move to accept.
Do a second?
Second.
Do you have any public comment? Have any comment from the board members?
We did have one public comment that I just need to mention that had come in. It was the same one we mentioned yesterday in executive staff, and it was just regarding bringing the public more involved in each of them, which we will do during the public sessions that we have on the objectives.
Sure. Can I get a speaker slip on that? Yes. Thank you. Okay, so all those in favor of the motion as stated, say aye.
Aye.
Any opposed? Okay, I would just ask that a clean copy in the next couple weeks come out to the board members so that we can attach it to our, because it's going to be an ongoing document, no? So we should have it or not?
This is going to be revised and finalized then for final vote with all of the edits and corrections at the February meeting.
So we need to have it in advance so people can take a look at it and connect the dots, okay?
Okay, we can do that.
Okay, so that's it?
That's it.
That's it. Oh, okay, well, then that's it. So do I have any suggestions for, we did vote.
Did
We
you
voted,
vote?
that's
Okay.
done.
Thank you.
Public speaking, done. Do we have any requests by members to have items put on the agenda for the next?
Not going to do the...
Oh, yeah, that's what I asked, and I'm sorry. Discussion of the strategic plan objectives, point 5, that's what I thought we were going to.
You're going to lose your board quorum.
Right, so we're going to lose our quorum, but we're going to conduct this as a committee of a task force. And we're going to move on item number 22, the discussion of strategic plan objective 5.4, the annual review of committees, the establishment of board committees, and whatnot. So let me frame this, I guess, in that, Kim, you want to start?
Absolutely.
You're going to present, oh, sorry.
And again, in the interest of time, what I would recommend is that we actually look at the committees. So if you would turn in your agenda to item 22 on page 152 through 154, and you will see the committees that are listed there in your packet. Staff's recommendation actually at this time is that you look at the executive committee and all of your mandatory committee, which are application review committee, special faculty permit review committee, special programs committee, and the midwifery advisory council. Those committees, we would recommend that they remain as they are right now through 2012, with the exception of the midwifery advisory council. And we know that they do have some authority to examine increasing the membership by 2, and that will be looked at in 2012. And to keep those on a quarterly basis for all of those, or on an as-needed basis for the applications.
So back up 10 seconds, okay? Okay. So what I'm hearing now, and this is okay, is that there is a request by the staff to review the committee structure as it is and take a look at what is necessary and what might not be necessary.
That's one of your objectives.
It's one of our objectives, but it's all of a sudden, fine. But so the issue is that do you want to go one by one on this? It's my understanding in the past, so let me just frame this for the board members. It's that my understanding is that the chair of this board will take a look at what committees might be necessary what new committees might need to be addressed, subject matter, what task force might need to be established to address specific issues, and that would go forward, and that was my impression as how things had happened. It seems now that what's happening now is that the committees that have been created by the board are going to be evaluated under section whatever of the strategic plan. And so to slow it down a bit, do you want to go one by one and go, instead of which ones are going to be removed and which ones are going to stay? How is it you want to do this?
Once I get done with this item in and of itself, and again, we won't be voting because we don't have a quorum, then I would move on them more in a one by one. These are all mandatory or committees that would be needed.
So which ones are mandatory? Slow it down.
These, okay. The executive committee.
Can you go in the same order that the pages are?
I can, yes.
Okay.
The executive committee.
Okay, wait.
And it's not a mandated one, but it's one that you would want to have as a board.
I'm looking at the committees of the board, okay? And
page 153.
Okay, thank you.
Okay,
I didn't have
all right.
it. Thank you.
Page 153. So the executive committee,
right.
The application review committee, and turning the page,
right.
The midwifery advisory council, special faculty permit review committee, special programs committee. All of those committees would be committees that would remain as such that they are with the membership that they have, and the same amount of numbers.
Right.
So we would be moving with those, and those would meet either as needed or on a quarterly basis.
Okay, does anyone have any questions on the required committees?
As defined. As defined, right, in what their requirements are and on these 2 pages.
Okay, does anyone have any questions? Okay, so we're okay on that one? Okay, continue.
Okay.
Good, thank you.
Then moving forward, what I would like to do on the next agenda, or the next type of committees, and I'm going to look to council because I think I can still do this, is I would actually like a hand vote of the members just to see which ones of these committees are the most important at this time. We actually have several committees here. We have about taking out enforcement licensing. We have 5 other committees that we need to prioritize and find out what the top 3 are. So I'd actually like to call the committee. I'm going to leave out licensing and enforcement, but I'm going to call for the rest of these committees. And if individuals could just raise their hand and identify which their top 3 are.
I don't think that you can do it that way. There's nothing, however, to stop members from sending to you, but not to each other, their top 3 choices in an email.
Okay.
As long as there's no discussion amongst the members as to which one are your top 3, and let me solicit a vote for my top 3. If it's straight information going to staff, it's okay.
And was the issue with these were all standing committees up until now?
These are all standing committees that have been implemented for one reason or another.
Okay.
But the idea is to help provide guidance on whether you would want these on a annual basis, a semi-annual basis, or quarterly.
Right. The issue is, anyway, so do you want to direct an email to staff, to the board, or you want the board to direct a response back, or do you want to?
At this point, my recommendation would be that we move this agenda item to the following board meeting.
Fine.
In the interim, can we not send you as if we would do a self-evaluation?
What we'll do is send out a request to all of the board members asking your top, rate the committees, and then if you think it needs to be on a quarterly, a semi-annual, annual basis. So we have some information to bring back to present to the board in terms of the needs of these committees. And also, we then can prepare information on what staffing we have to be able to take care of those needs. Because again, at our staffing levels right now, we can't take care of certain needs. That's why we have not had certain committees meeting.
So that is the issue, is the staffing issue. It's not the importance of the committee as to the importance. The issue is the staffing issue, and we have to help staff so that we have people that are able to staff the committees to identify what our level of comfort is with which committees, correct? You're going to put this off into prioritization, but you're going to put this up to the next board meeting, or are you going to send an email?
We will send an email out to get the feedback from the board.
Okay, that's what I was trying to get.
And
present
it at the next
Thank
board
you, that's what I was
meeting.
trying to get.
And also, it's to understand from you, if you think that a certain committee should be held twice a year or once a year, so we can look at planning for those committees, because we know that probably licensing and enforcement are high-level committees that this board would want.
Right, exactly.
Yes.
Okay, thank you, thank you. Okay, so now we finished with 22. All of 22 or part of 22?
That is the end of that item until next meeting.
We'll include the subcommittees and workshops in that.
Right.
Okay,
We'll
so
come
now
back
we're going
next
to
time.
move on to item number 24. Is that okay with everyone?
Yes.
24 is, do any members have any requests for items to be placed on the agenda for the February 2-3 meeting that will be held in San Francisco? Yeah, it does. There were items that were requested to be on this agenda, but were not able to be on this agenda because we expected to spend a couple hours on the strategic plan. And fortunately, we spent a couple hours on the board meeting. Yeah. But I would entertain an opportunity to put either, would you want to tell us what they were, or do you want to, board members, do you want to? Do you have
a
a list?
couple things.
Good.
Ms. Shipsky has asked for an update or clarification on medical marijuana, and that's a possible future agenda item, either February or in the future.
Right. What would be helpful if also CMA, because I understand they've just taken another position, if CMA could also present.
Yeah, if a bill is introduced, it might be a very good time to spend some good discussion on that, and it probably would be close to our board meeting.
Might I suggest that as part and parcel of that, then there also be a review of what the board's policy is on it, and the board's work previously has been?
Second, Dr. Levine would like to discuss the maintenance of licensure and certification, and again, this is on our list of issues that the Federation is looking at, as well as ABMS. So we will put that on when it's appropriate, related to those reports coming back or information. Another one is that in anticipation that the sponsored free healthcare event regulations are finalized or almost finalized, we need to put on the agenda an item to adopt a resolution to delegate to the Department of Consumer Affairs the authority to receive sponsoring entity forms pursuant to sections 1331.1A and B of the regulations that we have passed.
Okay.
So that would be on there.
We normally have regulations.
No, they're the ones that
I know, but when they come due, we do them, right?
No, these are the regulations that should be finalized. Right. But this is what we have to do as part of the regulations. It says we have to adopt.
Right, no, I understand, like we've done in the past.
Those are the items I had.
So, Dr. Salmonson, do you have
I
something?
think Ms. Simone has already alluded to it, but I have a real sense of urgency yet uncertainty about SB 100. So I'm not sure what.
So would you like a fuller discussion of SB 100?
Or is it, some of those things that need to be implemented on what looks like a fairly tight timeline, one being the supervision issue?
That would be a typical update that
So
we
it's
would
already
provide to you
automatically gonna
on
be
where we are. Licensing would be providing a lot of details because it falls under the licensing division.
Okay.
And we would be updating you on how we've progressed with the implementation.
So we don't.
So maybe a more in-depth discussion.
All right, well, maybe it needs to go on licensing agenda. Maybe it will automatically. That's.
Okay. Anything else? Dr. Dale or Ms. Shipsky, anything? Okay, well, anybody has any suggestions, they should feel free to contact the executive director directly. She's more than open to those suggestions, I'm sure, but, or not. But I would like that we try for the next meeting to, in fact, allow enough time for us to have enough discussions about the items that are on our agenda, that I always kind of feel like there aren't enough hours in the day, so I don't know how to do it better. I have to tell you, I think having the interim meeting of that one of the panels had was very, very helpful, but not helpful enough. So I don't know, I would look to staff to try and figure out a way that we can get more accomplished in less time. Okay? So on that, I will entertain a motion to adjourn. So moved. A second. So we're adjourning. No public comment. Correct.